All right, welcome folks and committee to what is the second judiciary meeting, joint judiciary meeting of the interim. We got a couple members that we're missing today, but I think everyone that plans to be here is here and ready to go. Committee, just a couple of things. First, today, if you haven't looked at your agenda, there is a tour at 4 o'clock today. And so I'm announcing that to the public as well. We will be on a tour at 4 o'clock, which means 3:45 is a hard stop for us today. So we're going to do our best to keep this show on time, but also just for your own participation in that, keep that in mind, be cognizant of the time so that we can make that and respect the clerk's time for that meeting. Otherwise, Mr. Co-Chairman, any opening remarks?
Thank you, Mr. Co-Chairman. Well, welcome everybody to Casper. Sorry it's so smoky, but I think lots of the state are under the even worse conditions than we are this morning. If for some reason we can't conclude a topic today, we still have another meeting. And so just because we don't finish a topic necessarily today, doesn't mean that the committee won't take it up at our final meeting in October.
Thank you, Co-Chairman Washit. With that, we'll go ahead and call the roll.
Senator Craigo. Here. Senator Crum. Senator Hicks.
Excused.
Senator Kolb.
Present.
Representative Brady. Here. Representative Bratton.
I think she's going to try and zoom in, but for now she's excused until she's present.
Representative Chestek.
Here.
Representative Filer.
Here.
Representative Kelly.
Here.
Representative Lean.
Here.
Representative Singh.
Here.
Representative Webb.
Here.
Chairman Washit.
Here.
Chairman Olson.
Here.
You have a quorum.
All right, excellent. With that, we'll move into our first topic, the strategic lawsuits against public participation. After following our previous meeting, we had a bill draft put together. LSO, do you want to walk us through that bill draft?
And Mr. Chairman, my apologies. I didn't know if the committee wanted to take action on the minutes from the May meeting.
Oh, yes. Has everyone seen and received the minutes from the previous meeting? All right, I'll entertain a motion to adopt those minutes.
Mr.
I'll
Chairman.
move.
Okay, it is moved by Representative Washit and seconded by Senator Craigo. Any discussion on the minutes? No. All those in favor signify by saying aye.
Aye.
Any opposed? All right, those minutes have been approved. Now we will jump into SLAP and we'll start with our legislation 27 LSO 0050 version 0.5.
Yep. And Mr. Chairman, my apologies. One more item. I just wanted to introduce our new colleague at the Legislative Service Office. John McCullough is a new senior legislative attorney. Today is his first day at LSO. So he is here with us at Joint Judiciary. I'll let John say a little more about himself for a quick minute. But he comes to LSO with just around 20 years of legislative experience in 2 other states. So we're quite thrilled to have him join us, and I'll let him introduce himself quickly.
Thank you, Mr. Chair, members of the committee. I'm grateful for the opportunity to work for the LSO and to serve this legislative institution. As Brian said, I've worked in 2 different legislatures before this, South Dakota and Minnesota. I have 19 years of legislative experience. So I'm happy to bring that experience here and add value to the work of the LSO, and look forward to meeting you all and working with you all. So thank you.
Welcome. We won't hold it against you that it took you this long to get to Wyoming, but we do appreciate you being here. You get to see the #1 hardest working committee at work. So it's a good trial by fire for you. All right. Now, Mr. Fuller,
Yes.
is it okay if we go
Yes,
into
Mr. Chairman.
SLAP legislation?
You got it. Mr. Chairman, 27 LSO 50, this is draft 0.5 Uniform Public Expression Protection Act. This is 2-01 in the online meeting materials. This bill draft would enact the Uniform Public Expression Protection Act, which provides procedures for addressing and reviewing strategic lawsuits against public participation. This bill, beginning just on the bottom of page 1, would create a new chapter in the Code of Civil Procedure in Title I. Page 2, line 4 is just a short title for the act. Then the first staff comment, Mr. Chairman, I'll come back to in a moment, but on page 2, line 21, this is a fairly important provision of this Uniform Act, and it provides that the act would apply to a cause of action that is asserted against a person based on the person's, and this is on line 25, first, a communication in a legislative, executive, judicial, or administrative or governmental proceeding. Second, communication on an issue under consideration or review in a legislative, executive, judicial, administrative, or other governmental proceeding. And then the top of page 3 is probably the broadest provision to which this act would apply. And that would be the exercise of the right of the freedom of speech, the freedom of press, the right to assemble and petition, or the right of association that are guaranteed under the United States and Wyoming constitutions. The staff comment just notes for paragraphs 1 and 2, if in light of that paragraph 3, if 1 and 2 are necessary, would be the first question. And then second, whether the term communication should be defined for purposes of this act. I think the question that came up during our review of this bill draft with paragraphs 1 and 2 is if the way they are drafted, if communication could reach something that was not necessarily covered under the First Amendment. For example, a person committing perjury in a proceeding, how that would be treated under paragraphs 1 and 2. Then, Mr. Chairman, moving on to page 3, line 10, the subsection C is kind of the second part of this act for this burden shifting framework that I'll describe later on in the bill draft. So on page 3, line 10, this act does not apply to a cause of action that is against a governmental entity or an employee or an agent thereof, acting in an official capacity. Paragraph 2, line 16, it does not apply to a cause of action by a governmental entity. And then page 3, line 21, the act does not apply to a cause of action against a person primarily engaged in the business of selling or leasing goods or services if the cause of action arises out of a communication related to that sale or lease of goods or services. Broadly put, it's a business exception to this act. Page 4, line 4, provides that the act shall be broadly construed and applied to protect the exercise of the rights of the freedom of speech, press, the right to assemble and petition, and the right of association. And then page 4, line 10 provides that in applying and construing this act, consideration shall be given to the need to promote uniformity of the law with respect to this act and the subject matter among the other states that enact this Uniform Act. Page 4, line 15 are the definitions that are applicable. First, goods or services, and this applies to that kind of business exception. That definition, any good or service that does not include the creation or dissemination of dramatic or literary, musical, political works. On page 5, the definition of governmental entity is more or less the definition of governmental entity that the state uses in the Governmental Claims Act. So it's intended to capture all governmental entities. And then page 5, line 14 is a definition of this act. The staff comment on the bottom of page 5 onto page 6, the Uniform Act includes a definition of person, but because Wyoming law broadly defines person in Title VIII, that definition is not necessary in this act. And just to recap, and that definition is on the top of page 6, the definition of person essentially includes any individual person and any sort of entity. Page 6, line 15, this section is the section that provides the ability to file that motion, that anti-SLAPP motion. So not later than 60 days after being served with a complaint or other pleading that asserts a cause of action to which this act applies, or at a later time if the person shows good cause, that person may file a special motion for expedited relief to dismiss the cause of action or the part that implicates the public participation. Then page 6, line 25, this new section would provide a stay. So if a person files a motion to dismiss, now I'm moving on to the top of page 7. Once that motion is filed, all of the proceedings between the moving party and the responding party, including discovery or any pending hearing or motion, are stayed. Page 7, the staff comment there just notes whether additional language may be necessary to clarify that proceedings for causes of actions or claims that are unrelated to the SLAP lawsuit could continue or not continue. Then page 7, line 19, if the moving party so moves, the court may stay a hearing or motion involving another party or discovering by another party if the hearing or ruling would adjudicate or the discovery would relate to an issue that's material to the motion to dismiss. Page 7, line 25 provides that the stay that would be entered would remain in effect until the entry of an order that rules on the motion to dismiss and the expiration of time to file an appeal from that ruling. Moving on to page 8, line 2, if a party files an appeal from a motion from an order ruling on the motion to dismiss, all proceedings between all parties in the action are stayed until the conclusion of that appeal. Page 8, line 8 provides that during a stay, the court may allow limited discovery if a party shows that specific information is necessary to establish whether a party is satisfied or failed to satisfy a burden in a court ruling on that motion to dismiss. Page 8, line 15 provides that a motion for cost, attorney fees, and expenses in connection with that motion to dismiss is not subject to any stay under this section. And then finally, page 8, line 20, a stay entered under this section shall not affect a party's ability to voluntarily dismiss a cause of action or a part thereof. Page 9, line 2, during a stay that's entered under this section, the court, if there's a showing of good cause, can hear and rule on a motion that's unrelated to the motion to dismiss or a motion seeking a preliminary injunction to protect against an imminent health to the public welfare or safety. Page 9, line 14 provides requirements for a hearing on that motion to dismiss, that SLAP motion to dismiss. So the court is required to hear a motion not later than 60 days after the filing of the motion to dismiss, unless the court orders a later hearing to allow certain discovery or for other good cause. And if the court orders a later hearing, the court must hear that hearing not later than 60 days after the discovery is allowed, unless a later date is specified after a showing of good cause. Then page 10, line 6, the court is required to consider the pleadings, the motion, any other reply or response, and then any evidence that could be considered in ruling on a motion for summary judgment. Page 10, line 12, this is this section, Mr. Chairman, I would characterize as that burden shifting framework for how a court would review and analyze that motion to dismiss, that SLAP motion to dismiss. So starting on page 10, line 15, the court is required to dismiss with prejudice a cause of action to which the act applies if, and then the first part of this on line 20, the first kind of burden belongs to the moving party. And the moving party has to show that the act applies. And they would do that, and this goes back to the very first section of the bill, subsection, so it'd be 101B. They have to show one of those 3 communications or the exercise of a protected right took place. Then moving on to page 11, line 2, the burden shifts to the responding party. That would be the person who brought the SLAP lawsuit in the first place. And their burden at this stage is to, they would have to establish that the act does not apply. If they do not establish that the act does not apply, then the motion to dismiss would be granted. And then finally, the last part of the burden, this is page 11, line 4, one of 2 things has to happen. So first, either the responding party fails to establish a prima facie case as to each element of the cause of action that they've brought, or the moving party is able to establish that the responding party has failed to state a cause of action upon which relief can be granted. Put another way, the moving party would win on a motion to dismiss standard. Or second, this is page 11, line 16, the moving party is entitled to summary judgment on the cause of action because the person who brought the lawsuit isn't able to raise a genuine issue of material fact, is the moving party to be entitled to judgment as a matter of law. Page 11, line 21 provides that a voluntary dismissal without prejudice by a responding party or a part thereof that's subject to the motion to dismiss shall not affect the moving party's right to seek attorney fees under the Uniform Act. Page 12, line 5 just provides that a voluntary dismissal with prejudice by the responding party would establish that the moving party prevailed for purposes of the attorney fees. Page 12, line 12 is an appeal from, is the ruling on the motion and then appeal. So first, line 14 provides that the court must rule on a motion to dismiss not later than 60 days after a hearing is held. And then second, page 12, line 18, a moving party who does not prevail on that motion to dismiss is entitled to appeal that. The Uniform Act, Mr. Chairman, provided that the appeal must be filed within 21 days. Here, I would just note that the rules of appellate procedure, this is Rule 2.01, allows a party 30 days to file an appeal from a dispositive motion or order that a trial court has entered. And so the committee may wish to consider changing that to 30 days to align with the rules of appellate procedure. Then page 13, this final section of the bill, it concerns the attorney fees. And so the court must award costs, reasonable attorney fees, and reasonable litigation expenses to the moving party if the moving party prevails on the motion to dismiss, or to the responding party, but the responding party must prevail on the motion. And then the court must also find that the motion to dismiss that the moving party filed was frivolous or filed solely with the intent to delay the proceeding. Then page 13, line 16 is an applicability clause. It makes it applicable to all causes of action filed on and after the effective date of this act. The staff comment just notes that the Uniform Act included a severability clause. But again, Title 8 includes that broad language for any bill the legislature passes, and I included that on the top of page 14. The act would be effective July 1st, 2027. With that, Mr. Chairman, I'd be happy to answer questions.
Mr. Fuller, so we used the Uniform Law Commission's or the Uniform Law. Other than I guess your staff comments there's no other changes that we applied to this bill?
So Mr. Chairman, the one change, so other than the staff comments where I omitted the severability, the definition of person, I would say the only other change would be the definition of governmental entity, which I used a definition that the state has used in several places in statute.
And Mr. Fuller, I did have a question about that in particular. Do we sometimes just sometimes in statutes just use agency, and that definition looks very similar, except I think it doesn't include like University of Wyoming in it.
And Mr. Chairman, I need to do a little more looking. I think the typical connotation of agency is state agency.
Is stated.
So it would not necessarily include, I think it would be arguable whether that term included local governments and other political subdivisions.
Okay. Very good. And then you don't have a staff comment on this, but you did raise the appeal issue of 30 days. That would be in line with Wyoming law.
Mr. Chairman, that's correct. That would be the 30 days is what the Wyoming rules of appellate procedure provide.
Great. Any other questions for Mr. Fuller? Senator Crago.
Thank you, Mr. Chairman. Thanks for the run through, Mr. Fuller. On going back to your comment regarding the definition of communication, did you have any of the other states done anything regarding that issue? Have they defined communication? Is there any case law defining that? Is there something we could look to in that regards?
Yep.
Thank you, Mr. Chairman.
So, Mr. Chairman, Senator Crago, I think most states that have adopted the Uniform Act have adopted this language pretty consistently. I think the commentary to the Uniform Act provides that communication should be interpreted as broadly as possible. And then, Mr. Chairman, the commentary does talk about, so in paragraph 3, it says page 8, line 8, there is a slight narrowing there in that the exercise of that right has to be on a matter of public concern. And so, Mr. Chairman, one option would be to reference that term in paragraphs 1 and 2, that the communication has to be, I'm not sure it fully solves the problem of, say, perjury in a judicial proceeding, for example. But that could be one way to try to tighten that up a little bit.
Representative Webb and then Senator Crum.
Thank you, Mr. Chairman. My question is words public concern defined anywhere?
Mr. Fuller.
So, Mr. Chairman, Representative Webb, the term matter of public concern is not defined in either this bill draft or the Uniform Act. But the Supreme Court has said that speech deals with matters of public concern when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is a subject of legitimate news interest, that is a subject of general interest and of value and concern to the public. So that's what the United States Supreme Court has said about that term matter of public concern.
Senator Crum.
Mr. Chairman, my question is on page 5, starting on line 2 with that section, bullet 2, how would this section affect 501Cs that have been set up as operating entities, say for hospital districts or those type of things? Are they included in this or not included? How's that work, Mr. Fuller?
Mr. Fuller.
Yep, Mr. Chairman, Senator Crum, I would have to do a little more digging into, I think it would depend on the facts and circumstances of how that entity is structured. Whether a 501c3 that, a foundation arm, for example, of a hospital district. I would have to do a little more research to see if that would be covered. If you just look at the plain language, it's the hospital district is covered. A nonprofit corporation would fall under the definition of person for sure, but may or may not fall under this. I think the question would be so page 5, lines 11 and 12, is that, foundation, for example, or other entity and instrumentality or institution of, say, a hospital district.
So, Mr. Fuller, is this definition of governmental entity verbatim from an existing statute, or did you craft some of the language for it?
So, Mr. Chairman, this is nearly verbatim. The one change I made to this definition from the Governmental Claims Act was there's a reference to certain out-of-state workers who would come to the state, I think for healthcare purposes. Since they were out of the state, I excluded them from this bill draft.
Any other questions? Yes, Representative Lean and then Representative Webb.
Thank you, Mr. Chairman. Thank you, Mr. Fuller. My question is about authors. Can you kind of walk me through? I see that on the bottom of page 4, we include literary materials. Could you walk me through what that means for our authors in Wyoming? Are we making sure that they're protected under this act as well?
Mr. Fuller.
Yep. So Mr. Chairman, Representative Lean, so that definition on the bottom of page 4 for goods or services, if it is a business transaction, that would be excluded from the act unless the goods or services are the creation, dissemination, exhibition, or advertisement of that dramatic, literary, musical, political, journalistic, or artistic work. So it's kind of like a double exception, if you will, but those individuals who do those works, artistic, literary, they would be protected. And then, Mr. Chairman, just one other note, the committee in May, the first meeting asked for information about whether any state, when enacting a SLAPP law or anti-SLAPP law, included coverage for religious expression. So there's a short memorandum. This is 2-02 in the online meeting materials. And I reviewed the approximately 40 states that had enacted anti-SLAPP laws and found only 3 examples where religious expression may be covered. For 2 of the states, Virginia and Maryland, the statutory language in their acts do not reference specific First Amendment rights. It just broadly says, it just broadly refers to rights under the First Amendment, which arguably would include that right to religious expression. I found only 1 state, Tennessee, that expressly stated religious expression. And they did that in the definition of exercise of the right of free speech to include a communication that's made in connection with a matter of public concern or religious expression. So just wanted to share that, Mr. Chairman.
And Mr. Fuller, just remind us how many states have enacted SLAPP legislation?
So, Mr. Chairman, approximately 40 states have enacted anti-SLAPP laws. Not all of those states, though, have enacted the Uniform Act.
That was going to be my follow-up question, was how many of the states?
I think between 16 to 20. I don't recall the exact number, but somewhere around half.
Perfect. Anything else, committee, for Mr. Fuller? All right. Thank you, Mr. Fuller. We'll move into, I guess the memo's already covered. So let's move to any governmental agencies wishing to testify on this draft proposal. If not, then I will go to Mr. Meyer from the Uniform Law Commission. Welcome, Mr. Meyer.
Thank you, Mr. Chairman. Members of the committee, Scott Meyer on behalf of the Uniform Laws Commission. I guess the first thing I'd like to say is that hats off to Mr. Fuller and his team. He did a great job explaining this stuff and has been able to find things faster than I could find on here. So I commend him for that. With respect to, I think the last time I looked, the number of states that have enacted some kind of a SLAPP thing, I think is exactly like Mr. Fuller says, about 40 of them. For certainly 32 that have been actually been in print and being effective right now. There's still a couple of them that are still looking at it. When it comes to states that have enacted the uniform laws version of this, we are at 18. My last check on that. I think I would just say that because of all those states that have enacted something like this, you find out that there's some very limited versions of this, and then there's some very general versions of this, and you start running into complications on how courts will look at this, because typically, as you all know, the courts will look at, see what other jurisdictions have done, how they've interpreted this, but it just covers a wide gamut of options out there, and I encourage the committee to adopt this because it is based on the uniform laws, and we do have a little bit more consistency on how that's applied. I think generally speaking, this Uniform Act really follows how the general legislatures have been doing this throughout the state, but they've been kind of narrowing things down as to having the differences between them eliminated. And so I think it helps everybody when it's uniform. I would add, I guess, when I look at the comments that the LSO has put in there, I think those are very valid comments. I think on the first one that Mr. Fuller brought up, boy, this one gets kind of complicated, I think, because I do believe that those 2 sections that he referred to that we may or may not want, I think we do want. But it does get kind of complicated as to how we define communication, because this thing changes as time goes on. But I do think it would be helpful, I think, if we do come up with a definition, and I'm not prepared to give you what I think it should be, but I do think it would probably be helpful if we did define what communication is. And knowing full well that the legislature will probably have to come back as time goes on, because we don't know all the different forms of communication. I'm starting to hear now that it's like smart watches are now going out of style because they're smart rings. I don't know how all this stuff works. But communication can be kind of nebulous when you get into it. I think his other comments were on there are very good. I especially like the very last one when he talks about the severability. I don't think that's needed. Other than that, when I looked at, other than just maybe some changing in the order of how things are presented, it's pretty much right in line with the uniform laws. I will point out, I guess, to you, Mr. Chairman Olson and Senator Crago and Representative Chestik, I haven't been in a courtroom for a while, so I wouldn't be able to sit there and talk to you about procedural matters. But I do think that the way that this is laid out it will be very beneficial to the people of Wyoming. I did have a request at one point in time from Chairman Washit talk about have there been any examples of how this has been applied in different states. I found an example of in Ohio and in Kentucky and in New Jersey and in Minnesota where it's been on both sides, where defamation cases have been stopped or been allowed to proceed forward or what have you. So we do know that it's being applied, this Uniform Act, and I think it's been applied very effectively. I think that, it gives the courts a lot of leeway, but we do have the appellate procedure to make sure that everybody is looking at this from the same standpoint. I think that it's, like I said, it's been very effective, and I think this is a best way to go forward if we're going to have this kind of legislation and every state's looking at it, that we try to do something very uniform. So on behalf of the Uniform Laws Commission, we stand in support of this bill. Certainly stand for any questions.
Representative Lean.
Thank you, Mr. Chairman. Thank you for joining us today, Mr. Meyer. My question is about the Tennessee addresses religious freedom and this one does not. Could you kind of give us what your viewpoint is on not including that in the bill and if there could be potential harms
Mr. Meyer.
to our Wyomingites?
Thank you. Mr. Chairman, Representative Lean, I don't know exactly I can't think of how that would work, really. I have not looked at the Tennessee law. I did read a summary that did in fact include religious aspects of it, but I don't think that that's anything that I would be afraid of. I think that would be something that would be fine as long as we could define it in what is included in those communications.
Representative Chestik.
Thank you, Mr. Chairman. Thank you for being here, Mr. Meyer. Getting to that point on communication, the definition of communication, I guess the concern that we have is we don't want to create a right to commit perjury, right? If we protect perjury, you can't, if that's not part of an anti-SLAPP suit, you can commit perjury without any consequence. Is there any other, so I'm just thinking out loud here, are there any other forms of communication that we should be concerned about besides the perjury problem? The perjury problem we could solve with an amendment pretty quickly, but I'm wondering if there's other kinds of communications that we need to be carving out so we don't protect other kinds of bad communication.
Chairman Olson, Representative Chestik, I am not aware of any. That's the one that came up, and I applaud Mr. Fuller for bringing that up. We certainly don't want to encourage that kind of communications. I do anticipate, I think that as time goes on, there will be other things that come up that we don't think of that the legislature will have to address, but I can't think of any representative that in addition to that, off the top of my head.
Sorry, Representative Chestik. Now I have to ask you a question because I'm not tracking with the perjury logic. If the matter is found, even if the person makes a false statement and the lawsuit is dismissed, how does that prevent a criminal action for perjury?
Mr. Chairman, I think the concern is that if a criminal prosecution for perjury, which is very, very rare, almost never happens that I know of, that remedy would still exist, but somebody files suit to prevent the perjury from happening or for the perjury to continue or to have whatever consequence the perjury has inflicted, that would be considered an anti-SLAPP suit, which would then be dismissed. So that this is, I think it would be excluding perjury from the reach of this statute would allow an aggrieved person to file suit to prevent the perjury from causing harm, I guess is what, so it's a different remedy. I don't think it does affect the criminal case, but the criminal cases are really just not that common, I don't think.
Mr. Fuller?
So, Mr. Chairman, maybe to answer your question, the act does not apply to criminal proceedings at all. This would only apply to civil proceedings. And Mr. Chairman, one possibility that may be simple would be if you go to page 3, there's that subsection C that says this act shall not apply to a cause of action. Mr. Chairman, on the top of page 4, the committee could add a paragraph 4 that just says any communication that is not protected by the First Amendment to the United States Constitution or Article 1, Sections 20 and 21 of the Wyoming Constitution. And that would then, by putting it there, the responding party would have to show that the communication is one that's not protected by the First Amendment in order to prevail on that motion to dismiss.
All right, Mr. Meyer, thank you. Unless you have some concluding comments.
No, but I'm just reading the faces of Chairman Washington. He looks like he has a question, so I didn't want to get up too quick.
I'm still pondering. Thank you.
Okay.
Actually,
I'll be around. So.
Senator Crago does have a question.
Oh, very good.
Thank you, Mr. Chairman. Mr. Meyer, just turn into page 13 on the attorney's fees provision. Just a couple thoughts, and I guess I'd like to hear your response or see what you think. One, the shell award costs, we don't do that very often in statute. I mean, we allow for the award of attorney's fees in a few places, but it's usually a may, not a shall. This will be one of the very rare circumstances where a district court judge can or has to award fees. And then second part of my question would be on the additional burden. So the moving party, if they prevail, they get their fees.
Right.
The responding party, they can get their fees, but they have an extra burden of showing that it was, filed with the intent to delay the proceeding. I'd rather us just say the prevailing party on the motion gets their fees if we're going to go with shall or may get their fees. Potentially, I'd prefer that too. But how do you feel about that? I understand that changes us from the uniform law, but it'd be more in line with how we do things in Wyoming. Thoughts on that?
Mr. Chairman, Senator Crago, I guess going in reverse order, but I do think, I guess from my own personal experience, I find it very difficult for courts to grant attorney's fees. It has happened, but I find it very difficult. But I kind of rely on the judges for that. And so I really don't have any opposition to saying, let's change the shall to may. I know that sometimes, at least under the federal statutes where people can get attorney's fees, things get a little kind of out of control. And so I really don't have a problem with that at all. Regarding, and you remind me again, your first question.
Mr. Chairman. So, Mr. Meyer, so it was two parts, shall to may was part of it. And then the second one is there's a different burden depending on which party prevails.
Right. Okay, so Mr. Chairman, Senator Crago, I would agree with you. It's almost like a part of it, you have to prove a negative. And I think that's very difficult. And so I do like the idea of just the prevailing party. Yeah.
Mr. Fuller, Senator Crago made me think about the language. This is a minimal issue, but it seems that costs and reasonable litigation expenses are redundant. I mean, typically in a statute, you would see reasonable attorney's fees and costs. Costs would be litigation expenses. I don't know if there's a legal difference between costs and reasonable litigation expenses, or if we should just tighten that language up.
And Mr. Chairman, the only item I could offer for that language is that's what the Uniform Act used. So I just kept it to be in line with that Uniform Act. I think, Mr. Chairman, costs have, would think courts would interpret that to include expenses.
Senator Craigo?
Mr. Chairman, I mean, I don't know if that would include, we do have two judges sitting out here that we could possibly ask, several judges. But that might include something like expert fees, et cetera, because costs is defined separately within the, within the rules and within the statute. So it might include stuff, litigation expenses might include something beyond costs. So just throwing that out there.
I also found it
Chairman,
interesting that the costs don't have to be reasonable.
Right. Well, Mr. Chairman, I would throw out too, that other than maybe the UCC, when we stick pretty close to it, Wyoming is very notorious for doing our own home cooking. And I really don't have a problem with those, something like that, to make sure that we've defined what exactly that is included.
Co-Chairman Washit.
Thank you, Mr. Chairman. Coming back to the question of communication. So when we don't define it, the court will apply reasonable interpretation of what communication. Have you seen in your research any evidence that that's problematic when the court simply uses its interpretation of communication as commonly understood?
Mr. Chairman, Mr. Co-Chairman, I would tell you, and I agree with the comments that Mr. Fuller made under the comments from the Uniform Laws Commission on the writing of this thing. It's supposed to be interpreted very broadly. And so I have not seen anything where I thought that this was, abused or anything else like that. And I don't know that there's anything that I think I would narrow that down. I would agree with the idea that the courts need to have some control over that and broadly determine it and decide what that is, because I would really rather have the courts decide that than try to put something in statute for that.
All right, this time you're off the hook, Mr. Meyer.
Okay, and I'm looking to see if anybody's starting to think about it. I'll run real quick.
Good plan.
Thank you, man.
All right, let's go ahead and move to general public comment. Anyone wishing to give public comment? Come forward. Who wants to go first? All right.
All right. All right, Chairman Olson, Chairman Washit, members of the committee. My name is Michelle St. Louis. I live here in Casper, and I'm here today to speak in favor of your proposed anti-SLAPP legislation with a few suggestions. First, I am currently being sued by a congressional candidate for things I said during his campaign for the U.S. Senate 2+ years ago. It is due to the pending litigation that I will be reading my attorney-approved testimony to you today. The word voters appears in the complaint against me 6 times following the statement on page 4 of the amended complaint that I have condensed for time. Plaintiff accordingly has filed the instant action to seek redress from defendants and to stop defendants from continuing to make allegations against plaintiff that are being offered to derail plaintiff's business and political interests. That statement alone puts a chill on free speech in this lawsuit, as my attorney stated on page 8 of our latest motion. It is noteworthy that plaintiff flatly admits in his first amended complaint that the purpose of his lawsuit is to silence the defendants from opposing his political aspirations. Simply put, my ex-husband and I are being sued for publicly participating in discourse about a candidate. Another concern is the chill this lawsuit puts on religious freedom. One of the claims against me takes aim at my biblical Christian worldview, calling it bigoted and antiquated. No matter the outcome of a SLAPP lawsuit, the cost of defending oneself becomes the punishment, even if the defendant prevails, which is why I had to take on a second job to make sure I can afford to keep my legal counsel throughout this process. But I am not willing to give up or be silenced, and I am more than willing to do what it takes to quite literally put my money where my mouth is to defend free speech and religious freedom. In a free society, no one should be able to use lawfare to silence those who say things that they do not want to hear. Disagreement is not hate. Liberty protects dissent. A judge should be able to hear all sides. There is merit to that, but the process is lengthy, and the longer a case takes, the more expensive it becomes, win or lose. That said, I think we have a great working draft before us, but I do have a few suggestions, and some you've already kind of discussed. I would be happy to help write amendments that expressly protect religious expression under Article 1, Section 18 of the Wyoming Constitution, and define communication broadly enough to include all current and future methods of communication. I do think there needs to also be some work when it comes to the being reimbursed for your expenses and the costs, because some of these cases are obviously malicious in nature. So with that being said, I support this proposed bill so no other Wyoming citizens have to take a second job or risk financial ruin before a court determines whether a lawsuit arising from protected public participation has merit. Chairman, members of the committee, thank you for your time this morning, and thank you for protecting free speech and preventing lawfare from turning our courts into a weapon against protected speech. And I will stand for any questions that I can answer to the
All right, thank you, Ms. St. Louis. Any questions for the witness? No? All right, well, thank you for sharing that with us and for offering to help write amendments. We appreciate that. You're up.
All right. Good morning, Mr. Chairman, members of the committee. My name is Parker Jackson. I'm here on behalf of the Goldwater Institute. As I've mentioned in a previous meeting, the Goldwater Institute is a public policy and a public interest litigation organization, and we work throughout the country on these types of issues to protect people's constitutional rights and public participation. You're all aware that the House had taken a position on a different bill during the session, and we had some discussions about that at our last meeting. And the Senate obviously had a different view. And so we went back and we tried to think, well, what's maybe a middle ground, and maybe how can we kind of bridge the gap between what the House was trying to do and what the Senate is trying to accomplish with some of the uniform provisions. And so we went and we took a look at those dozen and a half or so uniform states. And even though we use the term uniform, there is quite a bit of variation even among the UPEPA states. And part of the reason for that is some of the litigation that we discussed at the previous meeting, and I sent some of that around to you before the meeting. And we're trying to get to a point where the courts will recognize these types of bills not as procedural only, but as having a substantive component. And so we are impressed with some of the innovative steps that a couple of states have taken to try and take the best parts of the Uniform Act and try and address some of those litigation concerns. Ohio has added an immunity provision to their UPEPA-based statute. And we think probably the best drafted one is the one out of Pennsylvania. That one is currently being litigated in the Third Circuit, so we don't know exactly how that's going to pan out. But even if that doesn't pan out the way that some of us hope it would, there's no harm to the underlying UPEPA provisions in the way that Pennsylvania has structured their statute, because basically they took UPEPA, they added a section to it on, they do use the term immunity. And the goal of that is so that the courts will recognize this as substantively protecting constitutional rights, not just providing an expedited procedural mechanism, even though that tool is important as well. I had sent around some proposed amendments in that regard, and I'll just walk through a couple of those. We suggested some minor amendments to the title, again, just to point courts and that are looking at this bill in the direction of substance. I think the amendment we've proposed in subsection 101B would get at the perjury problem and maybe some of the other concerns. We suggest adding the term protected public expression, or if you wanted to make that even broader, you could just say protected expression in that heading or in that subsection B. Then that limits those communications. Those communications would have to be protected expression for them to qualify. So perjury wouldn't qualify under that proposed amendment. I've added the term substantively in subsection D of section 101. Again, just trying to signal to the courts that this is not merely a procedural tool. Because of the variation in the UPEPA states and because of the very deep divides among even the federal circuit courts of appeals on this issue, we suggest taking the uniformity clause out just because there's not really a way under the current state of the law to apply it uniformly. There, you have states all over the map and courts all over the map coming to different conclusions, even on very similar text. And we want Wyoming courts to be able to take a fresh look at this without being tied to one or the other, or potentially having conflicting court opinions that then they would be told to try and reconcile. The new insertion of subsection 103, that's the grant of immunity piece. That's almost word for word lifted right out of the Pennsylvania UPEPA statute. And the goal here is to not have the remedies tied to a specific procedural mechanism. So right now, the way that most UPEPA statutes work is you have to prevail on the special motion to strike. And some of the federal courts that have looked at that and they've concluded that because the remedy is tied to a procedural mechanism, that the remedy itself is procedural. And that's not where I think we want to land if we want this to actually be meaningful for Wyoming citizens. So the immunity provision, it gets at not just that special motion to strike, but as was mentioned, it could come up in a motion to dismiss setting, could come up in a summary judgment setting, or we've also added that this immunity could be raised in the pleading. So in an answer, for example. Again, it still tracks the federal standards for motion to dismiss and summary judgment, but it's not hooked to any one of those. The old 103, there's a line in there. Again, it doesn't preclude a party from asserting immunity, even if they've gone through, the other, that special motion to strike, so that those other procedural mechanisms are available. Jumping down to the current draft, subsection 108, right at the end of the bill, again, just essentially adding the words pleading, so that we can leave open other documents and other filings that a party might want to raise this type of immunity. Again, I know there were some concerns raised during the session about immunity not being tested. That's really not entirely true. This is, we would be the fourth or fifth state to do this. As I said, Ohio and Pennsylvania have both done it. Rhode Island's is not uniform, but they do use immunity in theirs, as does Virginia. And there's been some litigation in both of those states that could be helpful as well. And so we think this really is kind of a compromise, belt and suspenders type approach, where we can use the framework that the Uniform Commission has done the great work on providing, and also try and address those litigation concerns that have been flagged. Just a couple of brief comments on some of the other matters that have been raised already. There was the question about that Representative Lean asked about authors. I do have some concerns. We didn't suggest taking it out at this juncture, but we think it's worth discussing whether this should be limited to matters of public concern. Because I could envision a scenario where, an author or somebody publishes a book or makes a comment in private that's certainly protected expression under the First Amendment, but might not be on a political issue or, a hot topic of the day. And I think we would want this to broadly apply to all forms of protected expression to the extent that we can. We agree that 30 days is fine on extending that from the 21 days, just to line that up with the current appellate procedure. I do want to push back. I think that the shall on the attorney's fees is critical. And this has come up in some of the federal litigation. The reason why shall is important in the attorney fee context is because the courts have recognized that fee shifting as substantive. That converts it from procedural to substantive. And if you take the shall out, then we're back in procedural land where, it's tied to whatever the court determines. It also lessens the deterrent effect. Part of the point of these statutes is to deter the lawsuit from being brought in the first place. And if people know there's mandatory attorney fees, if they, run afoul of this, that's a huge benefit on the front end. Same thing with the prevailing. The prevailing doesn't really work because again, it's the shifting of the fee that is recognized in the federal case law as substantive. And that doesn't mean that somebody that can just frivolously bring these anti-SLAPP motions, there's already protections in the bill for that. Again, it does have to be shown that it's frivolous, but those types of cases are relatively rare. And if somebody has a plausible claim for anti-SLAPP protections, we want to give them the benefit of the doubt and not get them into a trap where there might be a legal question in a close case, and they're putting their fortunes on the line in trying to get a legal answer to that, which would kind of defeat the purpose of the statute. So that's all I have on the front end. I'm happy to answer any questions.
Questions from Mr. Jackson, Representative Chestik?
Thank you, Mr. Chairman, and thank you for being here again, Mr. Jackson. I was curious about the Pennsylvania statute, which you say is being litigated in the Third Circuit. Can you update me as to what the issue is there? What are the claims, and how does this bill address those claims?
Mr. Jackson?
Sure, Mr. Chairman, Representative Chestik. I can get it a little bit. The underlying claims I'm not entirely familiar with, but I am familiar with some of the procedure. The case that's active in the Third Circuit is one that I cited, Salam v. Trump. And the way it got up to the Third Circuit is a little bit weird because Pennsylvania kind of split its statute, and part of it wasn't immediately put into effect. And there's some reasons for that we can talk about later. But the question that the Third Circuit there's two questions the Third Circuit's currently considering. One is, does the statute apply in federal court? And is the order, if it's denied, if the motion to strike is denied, is it immediately appealable under the collateral order doctrine? I'm not going to get into the weeds on that. But I think, and I'll send this around after because I think this is helpful. What's interesting in that case, this was, like I said, it's still being briefed in the Third Circuit. There's been an opening brief and an answering brief, and some amicus briefs that have been filed. I think the most helpful one for this committee is the amicus brief that was filed. There's a coalition of free speech groups, the ACLU of Pennsylvania, Americans for Prosperity Pennsylvania, the Institute for Free Speech, which we heard from at our last meeting, Foundation for Individual Rights and Expression, and then some of the press groups. They filed a coalition brief in support of neither party. And the reason why they did that is because there are some questions about whether the motion was properly brought at all. But they argue pretty convincingly, I believe, that it should apply, that the immunity is carefully drafted to address the prior, and they go through some of the prior cases. Georgia and Maine have both had their anti-SLAPP provisions litigated in federal court. So I can get you a little more specifics on that. But it also addresses what the 10th Circuit flagged in the Los Lobos case that we talked about last time. And in that case, they found that New Mexico's anti-SLAPP statute, which is non-uniform, did not apply. And they looked at the legislative history and they found a draft legislative version that had immunity provisions in it. And the fact that the legislature didn't use those was a suggestion that it was procedural only and didn't apply. So we think that the language that we've proposed that tracks the Pennsylvania law will definitely help if the Third Circuit, overturns the decision in that case, that it didn't apply, but it also directly addresses what our 10th Circuit has already said about the immunity provision.
Yes, please.
Thank you, Mr. Chairman. I'm still a little confused. Pennsylvania statute does create immunity, and there's some procedural wrinkles going on, which you described in the case, but I'm still not clear as to what is the substantive argument about why immunity is not appropriate. Mm-hmm. So can you get to the immunity issue directly?
Mr. Chairman, Representative Chestik, the reason why the immunity is being argued is because immunity is typically viewed as immunity from suit, not just immunity from liability. And the entire purpose of the anti-SLAPP protection is to protect people from suit for protected expression. The argument against that, as I understand it, is that, they want to just speed things up in the process. That we still have to go to court, we still have to have this lawsuit, but that really is just a question of, well, how burdensome is the litigation going to be, not whether the litigation is appropriate in the first place. And so the immunity provision says that when there is protected expression, litigation is not appropriate at all, and that the person that brought that litigation should bear the costs.
Representative Lean and then Co-Chairman Washit.
Thank you, Mr. Chairman. Thank you for joining us today. My question for you, excuse me, is about the religious liberties piece that is not identified for the Wyoming folks. Would you anticipate that there could be potential harms by not including it in this legislation?
Mr. Jackson.
Mr. Chairman, Representative Lane, the Goldwater Institute doesn't take a position on the religious expression piece, so I'll put that out front. I will note that the federal courts do struggle sometimes in drawing a line between what counts as speech and what counts as conduct. And there's a category of what we would call expressive conduct that sometimes can be protected under the free speech clause, sometimes might be protected under the free exercise clause. So that's something you can consider as a policy matter. I will also note that Article 1, Section 18 of the Wyoming Constitution is textually distinct from the First Amendment and probably provides broader protections for religious expression than does the First Amendment.
Co-Chairman Washit.
Thank you, Mr. Chairman. So, Mr. Jackson, in your opinion, would Wyoming be better off with the original draft here that we're starting with without the amendments that you're proposing, or to have none at all?
Mr. Jackson.
Mr. Chairman and Mr. Chairman, I certainly think that having something is better than nothing. There's a couple caveats to that. One is if it's purely procedural, we've already talked about that may not apply in federal court. I wasn't sure whether I was going to bring this up, but I will bring it up because since you asked and because I'm going to share this Pennsylvania brief. There is a potential concern that if the bill is purely procedural, it may raise separation of powers concerns under the Wyoming Constitution. Representative Chestik, I believe at last meeting, kind of raised the distinction between procedure and substance is usually a legislative thing. That's something that it is addressed in the Pennsylvania law. The Pennsylvania law specifically separates out the immunity piece and says that the substantive immunity piece goes into effect on the effective date, and the procedural piece only goes into effect once the judiciary makes conforming rules to put that into effect. So if we go with the current draft, that's a risk. And if that plays out to its potential conclusion, we'll be back here in a year or two talking about this from scratch again.
All right. Thank you, Mr. Jackson. Nope, it's too late. You gotta be quicker. Oh, you can ask that. Yeah. Go ahead, Representative Singh.
Thank you, Mr. Chairman. Just a question for LSO. Mr. Fuller, can you tell us about you did an analysis of all the states that have similar legislation to what we're talking about. How many of them have also enacted their own Religious Freedom Restoration Act, similar to how we did in 2025? And how is that interacting with the description of sincerely held beliefs?
Mr. Fuller.
So, Mr. Chairman, Representative Singh, my research, I limited it only to reviewing the SLAPP laws of the state and just to check to see if they included religious expression in those laws. I did not look to see if other states had enacted Religious Freedom Restoration Acts similar to Wyoming's or the interplay between those laws.
Any follow-up? All right. Anyone else in the room wishing to testify? Yes, Ms. Shaner. Is there anyone else that's going to testify on this bill? Raise your hand if you are. Okay, great. Yeah, I got a couple online.
Yeah, but Mr. Chairman, I would just ask those who do wish to testify online if they would raise their hand on Zoom so we would know. Thank you.
Sounds good. Welcome.
Good morning, Mr. Chairman. Mr. Chairman, it's nice to see you, members of the committee. I'm Marcia Shaner. I am with the Wyoming Trial Lawyers Association, and we appreciate the work of this committee on this important issue. We have participated the last couple of years as you've considered the last two bills that were in front of you. We just have really one comment or suggestion today, although we haven't seen Mr. Jackson's amendments, so we may have concerns. We did have concerns, excuse me, I'm sorry, with some of the language that was included in the last two bills, the previous 2 years. So we may have some thoughts if those are added. We just would like to suggest that you include in the exceptions that begin on page 3 and end on page 4, the inclusion of an exception for personal injury cases. These cases are not contemplated to be part of the constitutional protections that this bill addresses. And so perhaps a small number 4 could read something like seeking recovery for bodily injury, wrongful death, or survival, or to statements made regarding that cause of action. And then we know that personal injury cases aren't going to be delayed or brought under this act. And that would really be our only suggestion, and until we see some of the amendments that perhaps are made today. And I'm happy to answer any questions that I'm able to answer.
Committee, any questions? Yes, Representative Chestick.
Thank you, Mr. Chairman. Ms. Shaner, thank you for being here. I guess I'm a little confused. In what way would a personal injury action be a matter of public concern? That seems like a private matter between private entities. So aren't you already covered because the speech that is being protected is that of public concern, and personal injury doesn't seem to be in that category. Can you help me with that?
Mr. Chairman, Representative Chestick, I think it has more to do with comments maybe perhaps made around those cases. There's press and other kinds of interviews that have to do with personal injury cases. I know that Texas and Washington State have both added that exception. And a few other states, their anti-SLAPP bills have been found unconstitutional just because the exceptions aren't broad enough. That isn't really a very good answer to your question, and I can try and bring more to you.
All right. Thank you.
Thank you.
Is it just Representative Ottman that raised her hand, or is there others?
And from the list I provided, there is Mr. Scheffner from the Motion Picture Association.
Okay, let's bring in Representative Ottman.
He's on.
Welcome, Representative Ottman.
Good morning, Mr. Chairman and committee. Hope everyone is well. Thank you for giving me this opportunity to address you. First off, I'd like to say that this has been very interesting over the last couple of years. I've learned a lot about different entities and how things work. What I would like to say, and I'll make it brief, is one, that you're taking this up as an interim, I believe, is the best way that could have went, because there was a lot of concern at the very beginning of misunderstanding what it was trying to do and the verbiage and the length of pages and all those things. And hopefully we're whittling that down. But what I'll say is, after I have looked at UPEPA and the different states and what is going on and the concerns that are there as well, yes, some see it's kind of humorous. I'm not of the attorney education, of course, but I do help to make law for the state of Wyoming. And so what it is that I would like to just say is that this was brought for the protection of the people of Wyoming against fraud. There's a lot of things being put in there, and I'm sure that it's very important that they're in there. But I hope that the primary reason that this litigation does go forward and is adjusted in whatever way it may need to be is not to make it a lot more than and not make it a lot of interpretation, but just to make good law, that the people of Wyoming are protected against fraudulent lawsuits, against having their public participation speech protected, First Amendment speech protected, and that a lot of fingers in it doesn't make it messier. I'm hoping that the law will be relatively clear, and that we can, instead of expanding the times in court or expanding the time of discovery, that it would get back to the basics to see whether or not free speech is permitted in this case, and whether or not a suit has merit or whether it doesn't. As far as the last testimony that said to add a lot of these things or to leave out some amendments may make it that we would be back here in a couple years. We have people right now that are losing their homes and losing their land and losing their ranches and losing their rights and spending years in court for suits that don't have merit. And I hope we don't, I hope we get to the push of it and don't make more people suffer for this length of time. So thank you, Mr. Chairman, for this opportunity. I appreciate all the work that you all have done through the interim and look forward to seeing this in session. Thank you.
Any questions for the representative? Thank you, Representative Ottman.
My pleasure.
We'll move to our last individual, Mr. Scheffner. You're up.
Chairman Olson, Chairman Washut, members of the committee, thank you for the opportunity to testify today in support of the Uniform Public Expression Protection Act, or UPEPA. I have approximately 3 minutes of prepared remarks, and then I did want to take just a minute or two to address some of the questions or suggestions that have come up during the course of this hearing. My name is Ben Scheffner. I'm an attorney at the Motion Picture Association, which represents the major U.S. motion picture and television producers and distributors. That's Paramount Pictures, Sony Pictures, Universal, Disney, Warner Brothers, Netflix, and Amazon. But equally important for today's purposes, I served on the Uniform Law Commission drafting committee that produced UPEPA in 2020. So I've been involved with this act from its earliest stages, and I'm happy to answer any technical questions the committee may have about its provisions. The motion picture industry has a particular interest in this legislation. Our member companies and their affiliated news organizations engage every day in constitutionally protected expression. They make fictional films and television programs, produce documentaries, and report the news. Sometimes that expression is controversial, and sometimes people or companies who dislike how they've been portrayed respond with meritless defamation, privacy, or other lawsuits, with the ultimate goal of censoring such portrayals. These are strategic lawsuits against public participation, or SLAPs. Even a meritless SLAP can cost a defendant hundreds of thousands of dollars and years of burden and distraction before it's ultimately thrown out. For a filmmaker, a local journalist, or a small production company, that cost alone can be enough to kill a project or chill the next one before it's even started. UPEPA gives defendants a fast, fair, and uniform way to get these suits dismissed early before they can inflict that damage, while still preserving a plaintiff's ability to pursue a genuinely meritorious claim. It does this by allowing an early motion to dismiss, staying discovery while that motion is pending, and shifting fees to compensate defendants who prevail. 41 states and the District of Columbia already have some form of anti-SLAPP protection. UPEPA offers Wyoming a modern, carefully balanced version that draws from time-tested anti-SLAPP statutes in both red and blue states and has won support from advocacy groups across the political spectrum, including conservative and libertarian organizations like the Institute for Free Speech and the Institute for Justice, the National Taxpayers Union, and the National Right to Life Committee. While I represent the major movie and TV studios, I want to be clear. This is not an industry-specific bill, and its benefits extend well beyond our member companies to small-town Wyoming newspapers, residents posting a review of a local business, and ordinary Wyoming citizens speaking out on political or social issues that matter to them. We urge the committee to advance UPEPA, and I'm happy to answer any questions. And if I could take just a minute or two to address some of the comments or suggestions that were made earlier in this hearing. First has to do with the attorney's fees provision. We believe it's very important to maintain the word shall. In other words, if a defendant prevails on an anti-SLAPP motion, that defendant should automatically get his or her attorney's fees. We feel this is very important to make sure that a defendant who was unfairly sued for exercise of his or her First Amendment rights is fully compensated for the damage that was done to that person. And that is quite, that's a common provision, not just in the other states that have enacted UPEPA, but in states that had strong anti-SLAPP statutes before UPEPA was ever conceived of. The second, there was some discussion early on about how the bill would apply in the case where somebody commits perjury. As I think it was Mr. Fuller who pointed out, perjury is a criminal concept. And this this bill has nothing whatsoever to do with criminal law. If somebody is guilty of perjury, they can still be prosecuted, and this bill would not interfere with that whatsoever. On a related note, I think it was Mr. Fuller who had floated the suggestion of an additional exclusion for speech that is not protected by the Constitution. And I think that is a little bit of putting the cart before the horse, because remember what the statute does, or what the bill does, is set up sort of several stages. And the first stage is just determining whether the statute applies in general. And that's where you have the three prongs about speech before a legislative body, et cetera. And just because you are sort of within one of those categories, that does not mean that the defendant prevails on its motion. All that means is you're within the scope of the statute and you proceed towards the to the next stages. So if, for example, somebody is accused of defamatory speech, making defamatory speech, it might be that speech might be within the scope of the statute, but the merits of that claim are adjudicated under prongs 2 or 3. So it would be premature to sort of import that analysis of whether it's protected speech into that very first initial stage. So those were the three things that I wanted to address. I'm happy to follow up with the committee or staff afterwards, but again, very much appreciate the opportunity to testify today and happy to answer any questions.
Any questions for Mr. Schaffner? Representative Chestik, go ahead.
Thank you, Mr. Chairman, and thank you, Mr. Schaffner, for being here. You probably heard some of the conversation with one of the prior witnesses, Mr. Jackson, about the desire, and I agree with the intent to try and make this a substantive right that would apply in federal court. So in a diversity case, we can still file the anti-SLAPP provisions would still work in federal court. I'm not sure that immunity, calling this immunity is the way to do it. What is your view on whether we need to create an immunity concept to make this a substantive right, or can we just, as one of the amendments that Mr. Jackson suggested, just insert the word substantively in the appropriate spot? Would that be sufficient to create a substantive right that is applicable in federal court?
Mr. Scheffner?
Thank you for the question. So just to take a step back, so this has been a long-running dispute in the courts about whether state anti-SLAPP statutes apply in federal court. And going back to what we all learned in law school about Erie Railroad versus Tompkins, state substantive law applies in federal court, state procedural law does not. So there's been a lot of debates for over a decade in the federal courts, going all the way up to multiple circuit courts about whether anti-SLAPP statutes apply in federal court. So one sort of idea that has been enacted in Pennsylvania and a couple other states is to try to say, well, we're going to put right in the statute that this creates a substantive right or an immunity. It's unclear whether that will be effective. Mr. Jackson talked about the Salam versus Trump case, which is currently pending in the Third Circuit. There's actually a case on a closely related issue where there's a pending cert petition where this U.S. Supreme Court has asked for a response to the petition. I am hopeful that the steps that Pennsylvania took to create this immunity provision will lead the Third Circuit to say, yes, it does apply in federal court, but I don't think we have a guarantee. And I mean, I guess I'm a bit neutral on the actual question you asked, but I don't think it would hurt were Wyoming to do something very close to what Pennsylvania has done. I think it's possible that it will work, but I don't think there's really much downside to doing that either.
Any follow-up? All right. Thank you, Mr. Scheffner.
Thank you.
With that, let's go ahead and close public comment. Committee, what is your pleasure? Would you like to advance this bill? Move the bill? Okay. Been moved by Representative Chestic that 27 LSO 0050 version 0.5 become a bill sponsored by this committee. Is there a second?
Sorry.
It's been seconded. Okay. Now we can talk about some amendments, as I'm sure there are a handful of them. Yes, Co-Chairman Washut.
I would move that on whichever page we're on with the 21-day versus 30-day. On page 12, line 21, we change the 21-day provision to a 30-day provision.
Okay, it's been moved by Representative Chesek and seconded by Senator Crago. Any discussion on this amendment? All those in favor signify. Oh, yes.
Thank you, Mr.
Representative Chesek.
Thank you, Mr. Chairman. I'm just not sure if I'm in favor or opposed to it. I just wanted to comment that I don't see the need for uniformity between 21 days and 30 days. Because the 30-day, the rules of appellate procedure apply to appeals of right from final judgments. And that's, you have 30 days to do that. This right on page 12 is creating a special rule for an interlocutory appeal. For those who on the committee who are not lawyers, that's an order that does not dispose of the whole case. So when the moving party, I file a motion, a SLAPP motion, which is denied, the case would continue on and I wouldn't have the right to appeal. So we're creating a right of appeal, which I agree with. But it doesn't, I think the 21 days is a proper limitation on an interlocutory appeal. It's a different kind of appeal than the rules that apply, that the rules of appellate procedure apply to. So I guess I would be opposed to this. It's not a big make or break issue for me, but I think because this is a special case, it's an interlocutory appeal, I do think the narrower window for appeal is appropriate.
All right, any other discussion, Senator Crago?
Mr. Chairman, I guess I'd just point out, this is just the deadline by which the appeal has to be filed. You can file it the day after your motion is denied if you so want. So we're not slow. I mean, it's not slowing the process down. It's just probably creating some uniformity for the lawyers who will be handling the case, who are used to 30 versus 21 days. They think they would have 30 days to, I'd rather have uniformity in the statutes, but you can appeal as soon as you want.
All right. All those in favor signify by saying aye.
Aye.
Any opposed? Well, I'm sorry, that was a little close. I might have to do a hand count. All right, that amendment has been adopted. Co-Chairman Washington, did you have any other amendments? Well, you've got the mic.
No.
No? Okay. Yes, Representative Singh.
Thank you, Mr. Chairman. I just wanted to talk about this with the committee, but the explicit protections for religious speech as outlined in the Tennessee bill, I don't know if we're able to include that type of language in our version, but I think that would be essential for the values I seek to represent here in Wyoming.
Okay, are you making a motion?
I would make a motion to include that. I'm not sure where to put that in, but I do think that, the language already exists in another state. And so if we could somehow insert that, I would want to do that. That is my motion.
Okay, it's been moved and seconded by Representative Lean. Discussion? Senator Craigo?
Mr. Chairman, we might ask Mr. Fuller, but I think on page 3, line 8, after on a matter of public concern, you could just add or religious expression. I think that'd be similar to the Tennessee language, but I bet Mr. Fuller could tell us exactly where to put it.
And
Mr. Fuller?
yeah, Mr. Chairman, if the committee wants to do something similar to what Tennessee did, that would be the appropriate place, I think, to do it, would be to say on a matter of public concern or religious expression.
Let's do that. That sounds like what the motion that Representative Singh made.
Yes, Mr. Chairman.
All right, the second okay with that? Very good. Any other discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment has been adopted. Any other motions, Representative Chesick?
Thank you, Mr. Chairman. I have two different amendments, both on page 4. On line 3, I am a little bit concerned about the perjury issue, and I think that the suggestion that Mr. Fuller made was a good one, to add a new subparagraph 4 right there at line 3, excluding any communication not protected by the First Amendment. I think that captures perjury and other forms of expression that are not protected. We're only going to exempt protected speech. I would move that as an amendment.
Second. Okay, it's been seconded by Senator Craigo. Any discussion on this amendment? All right, all those in favor signify by saying aye.
Aye.
Any opposed?
Nay.
All right, that amendment has been adopted. Additional amendments. Representative Chesick, go ahead.
Yeah, my second amendment is also on that page, and I am concerned about I would like to see this bill be creating substantive rights. I am still a little bit queasy about the immunity approach, but I do think adding the word substantively at the beginning of page 5, beginning of line 5 on page 4. So apply to substantively protect the exercise of the right of freedom of speech. I think that is going to go a long way, and maybe all the way, to making this a substantive right. So I would move inserting the word substantively on page 4, line 5 at the very beginning.
Okay. Was seconded by Representative Lean. Any discussion on this amendment? No. Everyone's good with it? All those in favor signify by saying aye.
Aye.
Any opposed?
No.
All right, that amendment has been adopted. Representative Webb? That was your amendment? Anything else? What about the definition of person? That's an easy, I think that's an easy one because it already exists in Wyoming statute, so it's unnecessary to have a separate definition as pointed out by the staff comment.
So, Mr. Chairman, my apologies. Just to clarify, since that definition is in Title 8, I do not think it's necessary to add a definition of person in this specific act.
Right. Is it drafted in there now? Or you're just saying you left it out?
Mr. Chairman, I left that out. Yep. And the staff comment I just provided the language
Gotcha.
of the definition in Title 8.
Gotcha. Okay. My mistake. We're good. Any other amendments? Yes, Senator Craigo.
Mr. Chairman, I think we heard from Mr. Jackson on page 4, lines 10 through 13 about the uniformity application provision. And it sort of, I guess, piqued my interest a little bit. That language is a little interesting. We don't see it all the time. I'm also a little bit nervous about those particular clauses or that language being included because a lot of the other states, the courts are, finding that this is not substantive law, it is procedural, et cetera. Do we, by including that type of language, do we, give credence to that thought process by the courts that this is procedural, not substantive, because other courts are interpreting other states as procedural, not substantive? Do we hurt the strength of our law by including that? I don't know. I don't know if we have to decide that today, but it's just one of the things that I think Mr. Jackson brought up that I don't know if it's necessary. I don't really think it's necessary in here, and it might actually hurt what we're trying to do. So I don't know the answer, but throwing that out. Yeah, I'll make it a motion, Mr. Co-Chairman.
All right, it has been moved and seconded. Any additional discussion? We still have another meeting we can pass this amendment and chew on it and decide, but we still have another meeting. All right, all those in favor signify by saying aye.
Aye.
Any opposed? That amendment has been adopted.
Discussion.
Any other amendments before we go into general discussion? Yes, Representative Webb.
Thank you, Mr. Chairman. Wondering if we still need to do a little bit more with the immunity. Maybe I'd like to make a motion that we accept the language for the immunity that I believe was Mr. Jackson presented in his amendments.
Page. Do you know what page that is? That where it would go?
On his, it's in the red, under 14103, grant of immunity.
So that's page 6, line 11, right after or right before 103. Is there a second?
Yes.
Seconded by Representative Lean. Discussion?
Could you repeat that, what the amendment is here?
It's in Mr. Jackson's emailed amendments.
Mr. Chairman, I have
Yes.
it. Could I read it?
Go ahead, read it.
So it would end up being page 6, line 21.
Oh, it's line 21? Oh, after 103, before 104. Yeah, that's right.
Yeah, at the end of that paragraph, we would add a sentence that says, a motion under this section does not preclude.
Moving this.
My apologies.
You on the wrong one?
At the beginning of that, it says, insert as Wyoming statute 1-44-103 and read the word a grant of immunity.
Okay, so I wasn't crazy. It is line 11. All right.
A person accused of the suit of a cause of action based on a person's protected public expression as described in statute, Wyoming statute 140-44-101, if any of the following paragraphs. Essential element of the cause of action, or 2, state a cause of action upon which relief can be granted. Section B would then say, there is no genuine issue as to any material fact in the person against whom the cause of action based on protected public expression has been asserted is entitled to judgment as a matter of law in whole or in part.
Any discussion, Representative Chestik, please?
Thank you, Mr. Chairman. This is not a deal breaker for me. I'm still a little queasy. I think we addressed this issue with the prior amendment, adding the word substantively, which I think is sufficient. This imports the whole concept of immunity is being litigated in other states right now. And if that fails, if we include this language, we fail too, maybe, or we're creating a bigger hill to climb to defend it. I'm really not comfortable with the whole concept of immunity to accomplish the stated purpose, which is to create a substantive right. I think we did it with the prior amendment, so I'm going to vote no on this.
Yeah, I would agree with Representative Chestik. I think we've already addressed it. It's not a deal breaker for me either, but I am a little nervous. Part of what is making me nervous is that we started with a uniform law that has been tried and tested in states, and now we're Wyomingizing, which is good. But there's a point in time where we butcher the bill to the extent that we don't know how it's going to be tested. We think we know how it's going to be tested, but it hasn't been tested. Versus the law as originally drafted has been tested. So I'm a little nervous to take it too far. But I think conceptually it's probably addressed by the previous amendment anyway, or by the substantive amendment. So I don't think it's wholly necessary. And, but like I said, I could probably live with it. Representative Washit.
Thank you, Mr. Chairman. I'll be a no vote on this amendment. I think we always have to be real careful with immunity provisions. It's always a balancing act when it comes to immunity. And it just seems to me that we can always come back and improve upon this act after we see the outcome of the litigation in some of these other states on this topic. And to put this in now on the assumption that that's going to all play out well in another state, I think it's premature.
My mic's not on, sorry. That amendment has failed. Are there other amendments? Let's move into just discussion, please. Co-Chairman Washit.
Thank you, Mr. Chairman. As I understood the motion is to make this a committee bill by our vote today. And I would urge the committee not to do that. Let's bring it back at our next meeting in a updated version, with the amendments built into it. We all get another look at it. As Ms. Shaner said, there may be different public comment with the amendments than there was public comment on the draft that we saw today. So I'd urge us not to vote to make this a committee bill today. In addition, we're short 2 senators today, which I think.
We're only short 1 senator. But we're always short 1 senator, so we're used to it.
Very good. Regardless, we're short a senator, and I think that makes a difference when we're approving bills for final passage.
Okay, so then procedurally, you can vote down this original motion, which is a motion to sponsor the bill. If you agree with Co-Chairman Washit, and then we can have a separate, we only don't need a motion. We'll just move forward to the next meeting. Yes.
Just a question.
Yes.
Would a motion to table be in order?
Yeah,
Next meeting.
yeah.
Well, I make a
That's what you
motion
want.
to table
Okay.
to the next meeting, Mr. Chairman.
Okay. Yep, it's been moved and seconded. No discussion. This, we'll just go ahead and table this to our next meeting. Thank you, Co-Chairman Washit. With that, let's go ahead and take a 10-minute break. Still a few of us kind of trickling in, but we'll go ahead and get started in order to keep this train on the track so we can make it to our tour at the end of the day. Next up for our agenda is the Escape from Adult Community Correctional Facilities topic. We'll begin that topic with a draft bill. Mr. Fuller?
Yep, Mr. Chairman, 27 LSO 48, draft 0.4, parole eligibility determinations amendments. This is 3-01 in the online meeting materials. This bill draft would provide that a person who has been convicted of or has an administrative determination of escape or assault with a deadly weapon is not eligible for parole on a sentence. So beginning on page 13 at the very end of that first page in 713-402B, language is inserted to say that a person is not eligible for parole in a sentence if that person, and then the new language would be the person has been convicted in the district court or has been found by a final determination of the Wyoming Department of Corrections administrative hearing process of having. And then the two paragraphs I included for the committee's reference, these would not be in the bill though if the bill were introduced as it's currently drafted. But the first paragraph on page 2, line 5 just says made an assault with a deadly weapon on any officer, employee, or inmate of any institution. And then paragraph 2 on page 3, line 14 is escaped, attempted to escape, or assisted others to escape from any institution. Mr. Chairman, I'm going to actually disregard the staff comment on page 2 and 3 because I believe the Board of Parole is going to propose different language from what was discussed in May. They had suggested the following change to paragraph 1 to change what was meant by an assault with a deadly weapon to reference the crime of aggravated assault and battery. But the Board of Parole, I believe, is going to make a different proposal for that paragraph today. The bill would be effective July 1, 2027. And Mr. Chairman, I'd be happy to answer any questions.
Questions for Mr. Fuller on anything but the staff comment? All right. Thank you, Mr. Fuller. We'll move to Mr. Shannon. If you have anything that you'd like to add since our previous meeting to this, you're welcome to. After the Board of Parole? Okay, let's go to the Board of Parole. You're ready to go. Yeah. Moved in and everything. All right.
Good morning, Chairman Olson and Chairman Washit and members of the committee. My name is Margie White. I'm the Executive Director of the Board of Parole, and we are very honored to be here today. Mr. Fuller has already given you the language of 713-402B. I would just like to say it has been on the books since 1947. I had to get my old father's statute books and look it up and determined it was passed in 47. This statute, although short and seemingly simple, creates procedural complexities when applying it to individual inmate sentences. I could talk for hours about this statute, but I will keep
please do. That'd be great.
All right, you asked for it. No, I'm kidding, Mr. Chairman. But I will keep my remarks short. I believe it was Director Shannon who asked for the introduction of House Bill 170 in the 2026 budget session. Because of problems with escapes from adult community correction centers, otherwise known as halfway houses. These adult community correction centers are located in Cheyenne, Casper, and Gillette. They are places where inmates go primarily as their final step before going out on parole. They are in a community. They're expected to have a job. They are expected to have UAs all the time, and they are expected back at the ACC at certain hours. And if they are not, then they can be declared an escapee, and DOC has a very strong and well thought out escape procedure that is gone through. So these are escapes not from prisons. We've only had one attempted escape from a prison at the state pen a couple of years ago. Almost all of the escapes are from the adult community correction centers. So it's very important to differentiate between court convictions and administrative disciplinary convictions. If an inmate goes AWOL at an ACC and the escape protocol is triggered, normally the escapee is found and taken to the sheriff's office, where then Director Shannon issues an arrest warrant you've already issued the arrest warrant and the escapee has been brought to jail. Sometimes the prosecuting attorney of Laramie County, Natrona County, or Campbell County will decide that escape charges should be filed. Okay. So that means then that the inmate, the escapee, remains in jail until those formal escape charges are resolved. Sometimes the prosecuting attorneys choose not to file escape charges, but DOC goes ahead and goes through the administrative disciplinary conviction and finds them to have escaped. Okay, so the way the board has administered this is if we get notice that there has been an escape conviction, we'll get the judgment and sentence. It says escape. That is conclusive that the inmate escaped. And I draft a document approved by the board. It's called Declaration of Parole and Eligibility. And we say, because you did this, you were court convicted under 713-402B, you are parole ineligible. Now the board has, I guess, always thought, this has been in the policies for years and years, that if a third party, such as a court, has looked at this, a prosecuting attorney has looked at it, and the court has said, yes, you are guilty of escape, that's all the board needs. The board took a different approach and takes a different approach right now if it is a DOC administrative conviction, okay? If there's no court conviction, but Director Shannon's department finds this inmate guilty of escape, then under board policy, that creates a rebuttable presumption of parole ineligibility. Now, what we do then is we bring the inmate in at the institution where he's located and say, hey, we're issuing you a denial and you are rebuttably presumed to be parole ineligible. But you can ask for an evidentiary hearing before the board to rebut that presumption. It's called a petition for review. It's been in our policies for years and years. I think that the board, I cannot say because it's been on the books, I went back to at least 2016. I think the board believed that maybe somebody, a third party, should look at a DOC conviction, a third party, as opposed
Ms.
to.
White, I'm
Yeah.
sorry. Can we ask we got a question pending that we want to ask
Oh, yeah.
Senator Kolb?
Yeah, thank you, Mr. Chairman. Just a question about parole and eligibility. Is that permanent? You never really stated. Is that a permanent situation or is it temporary? Could you help me out with that?
Ms.
question? Thank you.
Mr. Chairman, Senator Culp, it's permanent. The only way that an inmate who has been declared parole ineligible could get out from underneath that is to request a commutation from the governor. And those are very rarely granted. In fact, the board stops most commutation petitions at the panel level.
Thank you. Go ahead.
Thank you, Mr. Chairman. So I just think that the board thought that maybe the DOC would be like judge, jury, and executioner if the board didn't allow the inmate to at least request a hearing before an independent panel of board members. But this bill for both escapes and assaults with a deadly weapon would put court convictions and administrative disciplinary convictions on equal footing. So if a court finds someone guilty of escape or the DOC finds someone guilty of escape, then that inmate becomes parole ineligible. They're just on equal footing. And Director Shannon can discuss the due process that has been built into the DOC process. So the Board of Parole is okay, in fact, agrees with this bill. And escape was the original scope of the bill, but I asked Director Shannon if we could horn in on his bill a little bit and also talk about assault with a deadly weapon. So if an inmate escapes, attempts to escape or assists others to escape, they come under 713-402B. Also, if an inmate commits an assault with a deadly weapon upon any officer or employee of a correctional facility institution, that inmate too triggers parole ineligibility. The problem the board has had about 713-402B1 is that assault with a deadly weapon is not defined. So what the board has done since at least 2016 is bootstrap the aggravated assault and battery statute 62502A1 and 2, and the definitions of deadly weapon and serious bodily injury, and created a board policy that basically operates this way. If there's an assault with a deadly weapon, now you think of deadly weapon, you think of a gun. Fortunately, there are not a lot of guns in the DOC institutions, but there are homemade knives, shivs, things like that. If I'm an inmate and I have a shiv and I come at Director Shannon and just cut him in the arm or whatever, that's an assault with a deadly weapon. That triggers parole ineligibility. But the second part of the definition of deadly weapon brings in the question of serious bodily injury. Okay, so what we have done for at least 10 years is say even if there are fists involved or knees or elbows, if that causes a serious bodily injury, parole ineligibility is triggered. And I know Director Shannon will testify about this. There are a lot of fistfights, especially at the state pen. But most of the time, fortunately, these fistfights do not result in serious bodily injury. But there is a small percentage that do. And it's been the board's position that even if it's just fists, if you cause serious bodily injury to a correctional officer or to an inmate, then the board is going to look at parole ineligibility.
This bill again puts an administrative disciplinary conviction of a MJ-12 or an MJ-12P on equal footing as a court conviction for aggravated assault and battery. It would simply be self-executing that if the DOC found someone guilty of an assault that caused serious bodily injury, that inmate will become parole ineligible. And the way I view this is that it's now all in the Department of Corrections arena, and that the board will no longer have to make these determinations. And I'll say that for the Board of Parole, they make so many weighty decisions every month. They are not a power-hungry group of people. And so if this all, falls to Director Shannon, the board trusts Director Shannon and the DOC, and the board would agree with this bill. Now, it was Representative Washit brought it up in May that couldn't we do this all by policy? We could, and the board is very willing to change its policies and procedures to do that. But the problem becomes, and Director Shannon and I have talked about this, it could all just be thrown away or tossed aside if there's a new DOC director or there are new board members. So we would like it to be codified. Then it would, we would know the arena that we're working in. So we agree with the bill as far as putting administrative disciplinary conviction on equal footing with court conviction. Senator Olson brought up at the end of the May that perhaps we don't want to just refer to 62501, the aggravated assault and battery, because it also has attempt in there. And after I discussed this with our AG rep and discussed it with some board members, we agree with you, Senator Olson. We don't want to get into the attempt or the intent. If there is an act, an assault that causes serious bodily injury, that should make that person parole ineligible. And with that, I will conclude unless there are any questions.
Co-Chairman Washit.
Thank you, Mr. Chairman. So just a couple comments. My suggestion with regards to policy was not in lieu of a statutory change, but because the statutory changes are going to take months to come to fruition, that perhaps a board policy could be more expeditious. And secondly, the differentiation between assault and battery, in our statutes, an assault is an attempted battery, all right? So would it make more sense to talk about battery as opposed to assault in this language, or are you more comfortable with assault? And if so, can you explain why?
That is so, Mr. Chairman.
Yes, please go ahead.
Representative Washit, that is so interesting that you brought up this question, because I talked to Donovan Burton, our AG rep, and I said, this has confused me since law school. And I've been a lawyer for a long time. I said, Donovan, okay, assault is that you're putting someone in fear of it. Battery is the actual unlawful touching. And Donovan said, well, that's in civil law. Like if you commit a battery against me, I can sue you. He said that aggravated or assault and battery mean the same in criminal law. And he is far smarter and younger than I am. So I believe that Mr. Burton is correct. But do you want to, what I wanted to say was commit any act which results in serious bodily injury is what actually I wanted.
Yes, Senator Kolb.
Yeah, thank you, Mr. Chairman. Just, I want to go back into this fistfight scenario you had outlined as being an issue. And in the scenario of a fistfight, and you had a person who's the aggressor and a person who is the defender. And in the situation where the defender would cause, at the conclusion of this said fight, would cause serious bodily injuries to the aggressor. How do you handle that? Is that defender then considered the same as the aggressor originally? Just could you give me an insight on how you ferret out a person that's responsible, or don't you? I don't know. I am concerned though when you talk about that there's going to be a revocation of parole, and if you were the defender and you would basically defend yourself because you don't have, like you said, you don't have guns, and you would cause damage to the other said person who was the aggressor. How do you come out with the conclusion of who did what and when and why? I mean, how do you work through that process? Thank you, Mr. Chairman.
Ms. White.
Mr. Chairman, Senator Kolb, that I will have to defer to Director Shannon. But I would think that if they are both, fighting each other in committing serious bodily injury on both, they would both be convicted of an MJ-12. But I'm going to turn that over to Director Shannon.
Just a follow-up. That's the problem. We just outlined the problem with this. I think when you have a person who's defending themselves and they do whatever they're doing in a hand-to-hand combat situation, to judge them as equal. I mean, that's my problem with giving that kind of authority. I mean, I'd be against that. I mean, if that's the kind of position you're going to take, that they're both guilty, I don't understand why. But maybe, Director, you could help me with clarification on just how do you decide who the aggressor is when you have the two males and, somebody, do you know who started it? I guess I'd like to know more about just how the process works.
Director Shannon.
Chairman Olson, Chairman Washit, committee members, I'm Dan Shannon with the Department of Corrections. Chairman Olson, Senator Kolb, that is not the way as described. When an incident takes place, more especially when there's a violent incident, a serious incident review is conducted. It's conducted by an investigative committee. It includes testimony, videos, that's referred to the prosecutor. The example that you provided, if a person is defending themselves, that person is not charged administratively. And that has to be supported by fact. It can't be just what he said, she said type thing. It has to be supported by fact. And there's also appellant processes through that at the institutional level as well as central office. So there's a number of appeal processes to it, but it is solely based upon a strict investigation and review backed up by fact. We would not treat them the same, nor do we.
All right. Any other questions for Ms. White before we move to Director Shannon? Yes, Representative Lean.
Thank you, Mr. Chairman. Thank you for joining us today. My question is, how often are we taking up cases of bodily injury or the fistfights, the shanking, those types of things in the state of Wyoming?
Well, for those fistfights that cause serious bodily injury, they're very rare. I went back 5 years, and I believe that there are, let me just I'll tell you. In 2022, we had one. In 2023, we had six in 2023, one in 2024, and then 4 in 2025. So they are very rare. That's assaults with a deadly weapon, or how it's defined. Escapes, they're more frequent. And I could give you those numbers, but it's very rare. I mean, if you take the inmate population at what, about 2,300? Pardon me? 2,500. This is just a tiny, tiny percentage. And it just doesn't happen that often. But what we see is from the ones that I've reviewed, and I review all the MJ-12s and MJ-12Ps. I've done so since 2022. It's an inmate is just sitting there minding his own business, and another inmate or two inmates come up and start just walloping him. Now, a lot of times the correctional officers are able to stop it, before it goes much farther. But there are these circumstances where, because of these fist fights, or fists to the head in particular, that the victim has to be treated off-site and, sometimes has to be transported to a larger hospital than the hospital in Carbon County. So when they happen, they're very serious. And we don't even look at this unless they have been treated off-site. And a lot of times there are some permanent or seemingly permanent cognitive deficits that might occur. So.
Yes, Senator Crum.
Yeah, thank you, Mr. Chairman. My question is, and I'm looking at your written testimony here on the last page, the recommendation that add BI in there. It says committed an assault with a deadly weapon or any assault results in serious bodily injury upon an officer, employee, and inmate of any institution. My question, and it also ties back to on the draft bill, page 2, line 5 and 6. Why do we limit it? Why don't we just say attempted a deadly weapon, any assault, which results in serious bodily injury, period? What about a construction worker on site? What about a hospital, a doctor that's not any of the above? Why do we limit it with those three? And the same question would go back to the other section too, by reference.
Ms. White.
Mr. Chairman, Senator Crum, I am going to have to also defer to Director Shannon on that. I'm not familiar enough with the internal operations of the institution.
Director Shannon, do you have a response?
Mr. Chairman, Senator Crum, you are correct that it would not include, and we've had nurses assaulted and things of that nature.
Mr. Chairman.
Yes.
As a follow-up, would it make sense then just to end, bodily injury on period and just don't limit the statement there? Would that make sense?
Director Shannon?
Mr. Chairman, Senator Crum, it makes sense to me. Yes, sir.
Thank you. Follow-up, Mr. Chairman.
Yes.
And then just on consistency, back on page 2, line 5, it starts with made an assault. And in this section we talked about on BI in the letter, it says committed an assault. Would it make sense? I don't really care which way, one way or the other, but just to make either made or committed for consistency in the language? Or is there a difference reason we're using two different words there?
Yeah, I think that the made language is being replaced with committed in the, if you would adopt that amendment.
Okay. So that B would replace that BI. Okay.
Yes.
Got it. Thank you.
Yep. I think with your proposal, we'd replace it with committed any assault with a deadly weapon or any assault which results in serious bodily injury, and then end it there was what you wanted.
Perfect.
Yeah.
Okay.
Yeah. Mr. Chairman, that would be the new B1.
That's the new B1. Okay.
Okay.
All right. Any other questions? No, if not, we'll move to you, Director Shannon. Go ahead.
Mr. Chairman, committee members, once again, I'm Dan Shannon with the Department of Correction. Thank you for taking the time to address this matter today. My testimony may be kind of all over the map. I was taking notes as questions were being asked. Director White accurately presented what the board's issues and concerns, as well as with the department. Once again, I will begin by saying, we'll start with Representative Lean's question about how often. If you look for in 2024, we're getting a new, thanks to the body members sitting present here, we're getting a new offender management system because our records will only indicate what an incident misconduct would be. So the example is if you have a security threat group attack, you may have 4 individuals, but you may have 10 misconducts on assault. So it doesn't mean, so in 2024, we had 75 misconducts issued, and in 2025, we had 84 issued. The board went back, and Director White will correct me if I'm wrong. I believe since 2022, there was 12 individuals deemed ineligible for parole. A majority of those were not with a deadly weapon, but they were violent assaults. Representative Lean, you asked about how often it's a fraction of a percentage, but it's extremely serious. We've had people that are become paraplegic, paralyzed from beatings and things of that nature. It's very rare. We're very fortunate. We're not like a lot of departments across our nation, but it does take place. So approximately, I think 12 in the last 4 years is the individuals we're talking about. Regarding the AC, and going to Senator Kolb's question, I just want to reassure this board, it's an intensive investigation that's reviewed internally and externally. It's reviewed with the local law enforcement. And I said it's based on fact. But I want to be clear. One thing I'll kick back on Director White's to comment that, well, we don't want the DOC to be judge, juror, and execution. The Department of Corrections, we value our close working relationship with the Board of Parole. And I absolutely believe in the separation. The Department of Correction does not want the authority, nor should it have any concerns with ruling for ineligibility. That's why we separate the powers. The board must be separated from the Department of Corrections. So I do want to kick back a little bit on that. I also believe that rules should follow statute, not statute follow rules. I've always been kind of confused with that. So I've asked for House Bill 170 to come forward. And it has nothing to do, I'm not faulting the board. Margie and I have sat down many times and gone over case by case and on what's going on. And that's how we come to a conclusion here today. We had 34 since January 1st of 24. We've had 34 escapes from the ACCs, and we put hundreds of people through there. So it's, once again, it's also a small fraction, but one is too many. 12 individuals were ruled ineligible. 4 are remaining in county jails, but a lot of them expired their sentence just going through the process. So you're looking 12 out of 34. I don't think that's the intent of the act. The act's is clear. But there's something else I want to say too. The Department of Corrections currently has the authority. We can flatten inmates for egregious, for these types of behaviors. I could hold an administrative hearing by statute and governor's rules, and I can flatten them. When you flatten them, they're no longer eligible for good time, which I think is wrong, and it doesn't provide them an opportunity. The parole board by statute very clearly, if there's no statutory change, can rule. They have the authority to rule inmates ineligible, regardless if there's a weapon or not. That's not in question by statute and rules. The intent is to do it appropriately, do it and follow statute. So once again, I do not believe. I appreciate the parole board. Trust me, I'm certainly not going to be here. I don't know how long I'll be here. But in the future, we shouldn't base our rules and our statutes around the individuals, and it has a long-term effect. For us to not address individuals, I think that betray our citizens, create more victims, and then they come to the institutions and do exactly the same and have no accountability, I think is a huge mistake, and I'm working very hard on that. not to bring this forward, I think is incorrect because I very well, and I will, is start flattening the inmates. That eliminates, I mean, you never have an opportunity again to, and there I do think you're judge and juror. So we very clearly, we provide the administrative hearing, which is required by a number of reasons. It provides opportunities because there are wrongdoings. There could be a wrongdoing by a staff member. So that is reviewed so many times and there's appellant processes to it. And that's the extent of it. That's how we deal with it internally. And then it goes to the pro board. Then the pro board decides what to do and we respect whatever the pro board decides. It's just, we do need that separation. So the Department of Corrections does not have nor want the authority for parole and eligibility. Mr. Chairman, I'll stand for questions.
Co-Chairman Washit and then Senator Crum.
Thank you, Mr. Chairman. Director, appreciate you being here. So I just want to make sure we're clear on your comments about rules following statute. The existing statute does not specify there must be a criminal conviction for escape. So if the board were to create rules that said that you're parole ineligible if you're administratively convicted by the Department of Corrections, would that not be following statute? Do you think we have to change the statute before the board could make that rule change?
Director Shannon.
Mr. Chairman, Co-Chairman Washit, I don't want to speak on behalf of the board, what the board thinks it should do. I do believe we got here by, when you listen to Director White's testimony, because the board changes and the ideas and thoughts and views change and they don't believe that that is their interpretation of it. So.
Ms. White, did you have a response?
Mr. Chairman, Chairman Washit. Yes, the statute does not say convicted of escape or convicted of an assault with a deadly weapon. Well, I had not thought about that. I mean, our policies make a distinction between court conviction and administrative disciplinary conviction. Well, I think I would prefer that there be clear legislative direction and it be a court conviction or an administrative disciplinary conviction. Put those on equal footing.
Co-Chairman Washit.
Yeah, I have no opposition to creating a statutory language change that's being proposed here. My sense is what happens with these escapes that happen between now and March or now and July 1st, 2027. And that if the board's not likely to have, I guess we do have an election coming up, there will be some changes, but if the board were to change policy now to address these cases that might occur between now and July 1, 2027, I don't see where that would necessarily require statutory changes before that could occur.
Correct.
And then on a related question for Mr. Shannon. So this proposed language that commit any assault with a deadly weapon. And I keep coming back to our criminal statutes. It's, for aggravated assault, it includes causes or attempts to cause serious bodily injury. So my question is, if we use this language and someone swings at a correctional officer with a homemade knife, but misses and then drops the weapon, have they committed an assault with a deadly weapon? Or have they attempted to commit an assault with a deadly weapon causing bodily injury? So I just want to know for you, from your reading on this, is the language assault without any reference to attempting sufficient?
Director Shannon.
Mr. Chairman, Co-Chairman Washit, I think there's a clear separation there between attempt as you're aware, attempt and performing it. If the example that you provided is if a person did, and we just had it happen 2 weeks ago at our institution, persons, as you mentioned, attempt to harm a person, a staff member, but didn't make contact. That's referred to the local prosecutor and they're criminally charged and it goes through that sentence. That doesn't, I don't believe it meets the criminal intent. That would also involve ineligibility. So, well, I certainly don't have an objection to it. But if you're asking, my understanding was if you're asking, I would refer that for criminal prosecution for an attempt. And then the board would decide what it wants to do with ineligibility. As of this time, we're basing it on serious harm and injury where a person goes off site or is permanent damage. Mr. Chairman, may I go back to my testimony and make one other comment just for the committee so maybe have a little bit of clarity with the understanding?
Sure.
When we talk about parole ineligibility and we talk about what the two different agencies before you or how we're handling or addressing these issues, I want to be clear, we're not increasing. We're only working within the confines of the sentencing court. So there's no big bad wolf saying you're going to do an extra couple of years. You're going to be flattened. Whatever the court gets, that's the confines we work in. What we should not be doing, and by not taking the action, we're rewarding and we're providing earned time and good time to inmates that are certainly not doing it. So the example is if a person's doing it 3 to 5, the Department of Corrections doesn't say, well, you're going to stay for another year. We don't incarcerate and we don't release. We have to work within the confines and that's all we're asking. But I certainly don't believe in rewarding disappropriate behavior and then submitting, you know, here's the individual returning back to our communities to do more destruction. So I just wanted to make that clarity. Thank you.
Mr. Chairman.
Oh, yeah, Senator Crum, I forgot about you.
I'll meet you to forget, Mr. Chairman. Just a question. We're using like an inmate who got transferred out of state. A Wyoming inmate gets transferred out of state. They commit an assault on somebody in another state in another prison, and then they come back for parole here. Would this statute cover that action that took place out of state the way it's written?
Director Shannon.
Mr. Chairman, Senator Crum, we would follow the laws of the area where they're being confined. As far, and Marty may answer as far as the parole, meaning example, and we've had that where people have assaults and then they're charged in that state right there where they're confined.
Mr. Chairman, follow up.
Please.
So just clarify, let's say prisoner A went to state B and they committed an assault there. They're found guilty or whatever. Then they come back to Wyoming. They're in our prison system then. Would they be eligible for parole or would that exclude them from parole?
Mr. Chairman, Senator Kolb, administratively, while they're out of state, they follow our rules. So that would return and those reports as well as recommendations would be submitted to the parole board. So they would be held accountable for it, yes.
Senator Craigo.
Yes, thank you, Mr. Chairman. I think Senator Crum's bringing up a good point. I mean, based on the exact language that's proposed to us today, I'm not sure. So they would be ineligible if they're convicted in the district court, not any district court. And then also, or found by final determination of the Wyoming Department of Corrections. So in theory, and maybe you can help us with this, you'd have to have a separate hearing once based on what activity took place in state B, as Senator Crum said, because I don't think as the statute's written now, I think an action that happens in a different state is covered, but when we pare it down and define it more discreetly, I'm not sure it would. So thoughts on that, Director or Ms. White?
Mr. Chairman, Senator Crago. Well, if an inmate commits an assault in another prison, as I understand it, they would get an MJ-12P or an MJ-12. That's what the board looks at. So if we got a disciplinary report back that inmate B in Mississippi has been convicted of a major 12 or a major 12 predatory, the board would, under current policies, would trigger this rebuttable presumption of parole ineligibility. Under this, they would be declared parole ineligible.
Senator Crago.
Follow up, Mr. Chairman?
Yes.
I understand that, and I think that's correct. I mean, under current policy, the problem is I think you're going to have to rewrite your policy based on the passage of this statute. Were we to pass it, I think we're taking that authority away from you based on the language that's before us right now. So you would not be able to use an MJ-12 from a different state to determine ineligibility for parole based on the language of this. Thoughts on that?
Yeah, because this, to follow up with Senator Crago, the language on lines 1 through 3 on page 2, I mean, it specifically says a determination of the Wyoming Department of Corrections. So for the administrative aspect of it, it would have to be from our Department of Corrections, not from a Department of Corrections in another state. The top part of the statutory language is convicted in the district court, whatever that specifically means. I don't know that that's limited to Wyoming. That could be interpreted if they were convicted in another state. But I think for the administrative process, I think Senator Craig was right. The language that we have drafted right now would complicate your process. Director Shannon.
Mr. Chairman, I would make the comment that I believe you're absolutely correct. We're not just referring to inmates that are housed out of state. We have inmates moving every single day, going to county jails and going to, maybe going to Colorado and addressing a crime or a charge and returning. If these incidents took place in those facilities, we'd have the same incident that Senator Crago just spoke of.
Senator Crago.
Follow up, Mr.
Yes, go
Chairman.
ahead.
So Director, any suggestions on how we fix that loophole, or do you see it as a loophole? Is the DOC willing to have a separate administrative hearing for something that happens out of state?
Director Shannon.
Mr. Chairman, Senator Crago, the Department of Corrections is willing to do whatever is necessary, but we would not do that because that would be unfair. If we don't have control of the investigation and have the facts or how if we're not following the exact same procedure, it'd be unfair to the inmate, so we would not do that. As far as the ACC ineligibility, I think the current act covers that.
Mr. Fuller, I'm curious about the last comment on Ms. White's handout of the use of the language prisoner versus inmate. Do you know, do we use throughout our statutes the language prisoner? Is that why this statute uses prisoner, or do we use inmate at all in our statutes? Do you know?
So Mr. Chairman, two thoughts. First, inmate is used extensively throughout Title VII. And Mr. Chairman, I could not, and the reference, just to point it out, I believe it's page 1, line 12 of the bill draft. The intro to 402B uses the term prisoner. You go to page 2, line 6, paragraph 1 uses the term inmate. I'm not sure there would be any issue with conforming prisoner to inmate in the intro if that's what the committee desires.
It's not just it's not just the intro. It's on page 1, line 12 as well, where it says
Mr. Chairman, that's what I meant in
Oh,
B
that's
and B intro.
Oh,
is that is the reference to prisoner in current law. Yes, Mr. Chairman.
Gotcha. Okay. Any other questions for Director Shannon or Ms. White? No? All right. Thank you both.
Thank you.
We have a lot to decide here. Public comment. Yes, please come forward. Do we have anyone online signed up for public comment on this topic?
Yes, Mr. Chairman, we have Valerie Hoffmeister.
All right. Welcome. Yep, till it turns green. There you go.
Thank you. I apologize. I don't know how these work. I do have handouts if anybody needs them. Pile of them here.
Yes, so if you have handouts, our staff can grab that from you and then distribute that to us. And then just state your name, and if you represent an organization or an entity, make that clear to us. Otherwise, you're free to tell us whatever you want us to hear.
Okay. Mr. Chairman, members of the board, thank you. I am Nate Sakinga. I own a roofing company in Gillette. I took the day off to be here because this one matters. I'm not here to excuse a crime or to release anyone. I'm here to ask you not to hand the state agency a power that belongs to the courts, the power to take a term sentence and turn it into a lifelong sentence on its own internal finding with no court able to review it ever. And they've already done it. So we're not guessing about how this goes. Right now, a Wyoming inmate is permanently parole ineligible on exactly the theory this bill would put into statute. In the state's own records, the board's own executive director wrote, "There is no weapon involved. The charge was an assault, not a weapons offense." And there's references in the packet for docket numbers and everything on all of that. Then that same board barred him for life for an assault with a deadly weapon. The weapon was his bare fist. And this past May, in this very room, the department director and the board's own deputy director told you the current deadly weapon language does not reach a barehanded assault. So the state used a law its own leadership says doesn't reach this to take a man's parole for life. So notice why we're really here. If the current law already covered this, the department wouldn't need the bill. Asking you to make it qualify going forward is the admission that today it doesn't. And notice how it's sold. It's on your agenda as being about escape, but by the department's own testimony, escape is already covered. Escape is its own crime. The director told you that of the recent escapes, most were criminally charged. He also told you that by the time these cases run their course, the sentence has usually already expired. His words, the person's expired. We never address their ineligibility, and the deputy director agreed to it. Agreed it becomes, quote, a moot point. And the director admitted he can already hold a hearing today and make an inmate serve his full maximum sentence. So if escape is already covered, a crime plus lost time, plus a sentence that's usually expired anyway, what is this bill really reaching for? It is an escape. It's the power to take any internal finding in the department's own hearing and turn a term sentence into a life sentence for anyone. And you've just seen what that power does. They took a bare fist, called it a deadly weapon against their own records, and made it permanent. Because here's what that process actually is. It has the word hearing in it, but it's not a trial. There's no independent judge. The department runs it. There's nothing like a court's discovery or cross-examination. You don't get to see and test the evidence against you the way you would in a courtroom. And when you lose, the appeal goes right back inside the same two agencies, the department and the board, both part of the same executive branch. Think about what that means. That is a court reviewing its own verdict on appeal instead of sending it to a higher court. We would never allow that anywhere else in our system because a decision maker cannot be its own appeals court. And subsection F of this very statute bars the real courts from stepping in at all. So the decision answers to no one outside two state agencies. Not a court, not the public. As James Madison warned in the Federalist 47, all powers in the same hands may justly be pronounced the very definition of tyranny. And once an agency can decide for itself what counts with no court to check it, the line moves. If a bare fist can be called a deadly weapon, what stops a shove or grabbing someone's arm from being called one in the next hearing? And on the escape side, picture an inmate who moves into a new cell. A shakedown turns up a loose screw or a tool a previous occupant hid in a vent. With no real discovery to prove it wasn't his, no court to check it, that internal hearing brands him an escape attempt and takes away his parole eligibility for life. That's not far-fetched. It's exactly what a process with no independent judge and no outside review makes possible. And it's permanent by design, locked in the statute, so no further board can ever revise it. The committee often looks at how other states handle a problem, and other states have let an agency mark someone parole ineligible, still left a way back. Virginia lets its parole board revisit and undo a corrections ineligibility finding. This bill leaves no way back, no future board, no courts ever. Here's what it cost you. A prison runs on one thing, the hopes that good behavior gets something. Tell a man there's no way out, no matter how much he changes, you've taken away his reason to follow the rules, to better himself, to turn his life around. And you do this for every inmate. A rule that can never say you've earned another look isn't just tough. It's more permanent, more costly, and more dangerous inside. So my ask is narrow. A permanent parole bar is a life sentence in effect. It should rest on a conviction in a court of law. If an internal hearing is going to impose it, there has to be a genuine review by an actual court, not the agencies reviewing themselves. I'll leave you with 3 questions. 1, should the most permanent penalty short of a new sentence rest on an agency's own hearing or a conviction in a court of law? 2, is there any court in this at all, or only the same agencies reviewing themselves? And 3, is there any way back, no matter how a person changes? What reason, if there is no way back, no matter how much a person changes, what reason does anyone in that prison have to improve? The exact quotes and citations are in the summary handout. Thank you, Mr. Chairman, and I'm glad to answer any questions.
Committee, any questions? No. Yes. Representative Washit.
Thank you, Mr. Chairman. I didn't catch your last name when you introduced us, so I won't refer you by name, but if we were to put in the statute that you'd become parole ineligible for a period of years so that an escape would still carry that deterrent effect, that we don't want to encourage inmates to escape. We don't want to encourage inmates to assault others. But if they were parole ineligible for, let's say, 5 years, and after that 5-year period, if there's no further misconduct, they're again become parole eligible. Would that address your concerns?
Mr. Sikinga?
Was I supposed to shut this off in between?
You can leave it on.
Yes, I'm sorry. My name was Nate Sikinga, and some sort of way back is all I'm asking. The current process,
it's been mentioned several times that it eliminates a future board, a future department from ever being able to review this and overturn it. I mean, people do change. This takes away eligibility forever. So, a 5-year plan, I think that's a huge improvement over the current draft.
All right, thank you for your testimony. Director Shannon, can you come back up? Director
Mr.
Shannon?
Chairman,
Yes.
committee members, I'm Dan Shan with Department of Corrections. Thank you. I won't take more than a minute time. Thank you for allowing me to make some comments. In regards to Mr., hopefully I pronounce it right, Sakega, I really appreciate the public comment. I think the more public comment we have, the better policy that we have, and I welcome that. I just made myself, maybe I didn't explain well. Department of Corrections has no interest in participating in an eligibility process. I believe that has to be a separation of power. I believe the current language is corrected. When we spoke of power, in my 19 years with the Department of Corrections, we flattened one inmate out of tens of thousands. So I certainly don't believe that's excessive. When regarding to the people with the escapes, on an average, are gone for 24 days. And look, and the district attorney from our county here is behind us asking about the destruction that it can cause. When we talk about other states, the feds mandated a 10-year if you run away from a community correction center, dropped it by 40%. These aren't sentences that are lives. These aren't. These sentences still fall within the structure of the original sentencing. There's no additional time to be giving. And specifically, I won't discuss the case that was brought up about the individual because there's multiple litigations against the state from that. But one thing I didn't hear was accountability, public safety, and our victims. When individuals are violent and they destroy lives in our community, and then they come to in a structured setting, they're inside our institutions and they're doing the same. As I testified earlier, we should not be rewarding them by giving them earned time. They're still within the structure of the original sentence. They're violent in the community. They're violent inside our institutions. And this is such a so small percentage. You've got a handful of people. But what do you think happens when we release those individuals back? And I do respect the former speaker that came up here. I welcome any more, especially if it is against our thoughts and views. I welcome it. I think that's what makes us a strong organization. As I said, we did it one time in 19 years, but I'm advocating for the public safety, not to release these people sooner. I agree with the speaker that people have to have hope. Our success rate can compete with any department in this nation. And I'm very proud of the hard work that our inmates and our staff perform every day. In 2024, Mr. Chairman, in 2025, we had 0 assaults on our staff. We had 2 serious assaults within the year 26. So I think it's imperative that we hold these individuals accountable, and thank you for allowing me to speak.
Senator Kolb, go ahead.
Thank you, Mr. Chairman. Director Shaner, what's your opinion about the deterrent effect as it pertains to an assault, and then the inmates knowing that I assume they know they'll lose their parole, they'll be ineligible for parole if they get involved with such things. I mean, is that well known to the inmates that if you get involved with an assault like that at that level, you'll be parole ineligible? And your opinion about, is that a deterrent for people doing things like this that we don't want them to do because they'll face parole ineligibility? What's your thoughts on that, Mr. Director?
Director Shannon.
Mr. Chairman, Senator Kolb, thank you for your question. Two schools of thought on that. If you look at the escapes, we had 31 with 12 that are ineligible. Last year we had, now I don't have the exact number, but we had 74 misconducts for major assaults. And over 5 years, we had 12, once again, we've had 12 people rule that they were ineligible. So as far as it being a deterrent, I believe what we're doing correctly is it is not a deterrent. The Department of Corrections has a responsibility to protect our community and keep those folks inside. So I would answer Mr. Senator Kolb, it would be a deterrent if we were following it each and every time. Meaning we don't take 2/3 committed, nothing's done, 1/3 we address. That's why we're here today. I believe then it would be a deterrent.
Co-Chairman Washit.
Thank you, Mr. Chairman. So we heard the previous speaker talk about a case involving bare fists being ruled to be a deadly weapon. If a bare fist assault resulted in serious bodily injury, it would still be included here. I'm just wondering if we define the term deadly weapon to say that it's an instrument other than your body, right? Your hands, your feet, your knees. Would that be sufficient to meet the needs, the safety needs, the accountability needs within your department? Because if I'm thinking of a case where somebody uses their bare fist or their feet, punches somebody once, as opposed to causing serious bodily injury with that assault. But I see the previous speaker's concern, right? That a simple bare fist assault gets ruled to be a deadly weapon. Your comments, please.
I think that the way that I read it, Co-Chairman Washit, is I don't think that a fist is going to be determined to be a deadly weapon. The fist falls under the second part of the statute if it results in serious bodily injury. If it's just a fist that doesn't result in serious bodily injury.
But they've already determined it in the previous case that it was.
That the fist was a deadly weapon?
Mr. Chairman.
Yes.
Just to clarify, the current law, this is of that bill draft, page 2, lines 5 and 6. Right now, it only says made an assault with a deadly weapon. So that language about the serious bodily injury, that is the proposal of the Board of Parole to insert in that paragraph. Just wanted to clarify that.
And I guess Co-Chairman Washit, you're referring to bullet number 2 on the handout. I see what you're talking about. Director Shannon?
Mr. Chairman, Co-Chairman Washit, we've had several individuals that were permanently damaged, paralyzed from one punch. So.
Oh, Senator Kolb.
Well, thank you, Mr. Chairman, for the recognition.
I was debating it.
Oh, you're
in my
debating
head.
it? Well, I'm glad I finally
Let
won
him
on that
talk,
debate. Thank you, Mr. Chairman. Just for the edification of the audience in this committee, I assure you there are people who can commit deadly bodily harm with their hands. And I'm one of them. I'm a 4th-degree black belt, an expert in self-defense, hand-to-hand combat. And I can assure you I've trained many people, and there are other people out there that can do that. And I think the board, I mean, just for the edification that, no, it can happen. If you know what you're doing, it's not that hard. And determined folks, they have to have a mechanism. So I think it's appropriate language to talk about bare fists or, using your fists because they can be. I mean, but it takes, discriminate or determination, upon your folks' part. So I think it's appropriate that that language is in there because you need a tool to deal with the situation that might arise when you can see video and such and evidence you go through your process. So I think I assure everyone it's not that hard to do if you're trained and have determination. But so in your defense, I'd just say I see it as a real issue. Not everybody's capable of that, but there are people that are. So I think it would seem prudent that you have the flexibility to make that assertion or determination when you see it's appropriate. And I think, I don't know if you've run into those situations where people are just nasty and kicking people in the head and causing spinal injuries. I don't know what they're up to, but I'm sure they didn't punch them in the back, frankly. So maybe you could give some insight on the situations where it becomes some people using their bare fists and not picking up an object of some sorts, where you've determined that that was serious bodily injury. Maybe some more explanation, but for me would be helpful. Thank you, Mr. Chairman.
Director Shannon.
Mr. Chairman, Senator Cole, thank you for that talking point. Those are the majority of the offenses that are not, and Director White can discuss about that incident. Very few, as I mentioned, it's very few numbers. So if you look at, say, 74 incidents, now one may involve several people. If you look at 74 incidents, you'll get maybe 2 or 3, but those 2 or 3 are very serious to where we're in hospitals in Denver for a month, running up $100,000, $200,000 bills, things of that nature, only utilizing their hands as well as their feet. So with the current act, I testified in our May, I said, that's mostly what inmates are doing now. They're not using deadly weapons. They are using their hands and feet. And that's exactly what is taking place.
Representative Lean.
Thank you, Mr. Chairman. Thank you for rejoining us, Director. I have a question about the most serious offenders that you're talking about. Is there a problem with where they're being placed in the Department of Corrections? Are they at the wrong level of security? And is there a chance for them to advance to a higher level of a secured facility instead of a revocation of their option to rejoin society?
Director Shannon.
Yeah. Chairman Olson, Representative Lean, thank you for your question. I believe they are appropriately classified. I do. We have a non-subjective classification system, and I believe it works extremely well. It's validated almost yearly, so we're solid there. When I talked about the escapes and the assaults and things that have happened, like at our Casper ACC, and those were with minimum inmates. Sure, we do have gang issues, as all institutions do, but it's rare. I would answer the question this way. The majority of the assaults are at our penitentiary, and that's our highest custody, and they're classified as our highest custody.
All right, we're going to roll this forward. We have a little more public testimony to take, and then we can take action on this or move it to the next meeting. But let's finish up public comment. I believe we have one person online. All right, let's bring Ms. Hoffmeister in. Welcome, Ms. Hoffmeister.
Hi, I apologize. I'm in the middle of some work. Went longer than I thought, but agreed. Public comment is awesome. Your other public person, I would want to say I agree. I am also from Gillette, Wyoming. And I believe part of the reason this bill got started is from much pressure from me. And it's been added to, which is great. My question is for everyone is, why are we so willing to protect the aggressors and so not thinking of the victims and their right to be safe? I don't disagree with parole. I don't disagree with rehabilitation. I live in Wyoming for a reason, because we are a conservative state, and I still think personally we're a little bit liberal in our convictions against people who create or do crimes against people, and I feel like we need to get a little stiffer in that area, and fill our prisons with people who are hurting people. instead of people that are hurting themselves, but that's a different day. I apologize for the rant. As some of you well know, my daughter and son, I will not call them victims, I will call them survivors and warriors of a man who has escaped the criminal justice system in many states because he is a transient. My daughter had to marry him to live. My son finally felt safe enough for my daughter to to report him 4 years later. We did get 2 assault and battery convictions. He is a charmer. He is a narcissist. He is a psychopath. And I know this is very limited, but this is the reason for the bill. My daughter and son were victimized for years by this man. And when they finally were brave enough to report he was convicted, he knows how to play the system and he behaves very well. And I wrote many letters to the community placement places. Cheyenne did agree to take him. And as I stated in my victim impact letter, he escaped and he was gone for a month. 2 weeks later, we put nothing out there. Thank God we were notified in the middle of the night by the wonderful victim advocate people under the Department of Corrections. Ebony is amazing. So we knew to watch for him, but he is sneaky. He's a career criminal. And he was here stalking my daughter. It was verified by law enforcement here. I'm going to try not to get emotional. I apologize. Once Mr. Shannon became involved, we were able to thankfully get some numbers, get him, U.S. Marshals capture him. But he was here and he was stalking my daughter. He went back and Cheyenne never charged him because there was a change of, as Mr. Shannon and Ms. White talked about, there was a change of county attorney, prosecuting attorney. They were in over their heads with cases. He was captured. Everybody was safe. But there's no consequence for him. Absolutely none. And randomly, we get a message that he was had a parole hearing, which of course I was frantic, wondering how the hell you have a parole hearing when you just escaped or gone. U.S. Marshals had to come after you. There is no added consequence for this man. None. Because the county attorneys were too busy and over their heads, which I understand. And there's, in my opinion, should be a added 5 years on your parole. He does get a parole in a couple of years, not parole, because the board found it not to be, but he could have easily slipped through the cracks had I not been paying attention. And because administrative law does not allow for them to be charged as they would if it was criminal law. So the other gentleman, I understand his testimony, but I completely disagree. And this is why I disagree. I believe there needs to be a checks and balances, but our criminal system is so backed up that, as stated before, a lot of these people go without consequences. So if he gets community placement again, and that's the other thing that I had asked at the last meeting, is that I believe they should not get community placement again. So if your charge is 5 to 8, you're serving your 8, and you shouldn't get to serve that in a community placement or an honor farm when you've escaped. That's my opinion. And my other opinion is, does it matter if you're causing bodily harm to somebody? Does it really matter with what you're causing it? Does it matter if it's a weapon? Does it matter if it's your fist or if it's your foot? You did it. It doesn't matter how you did it. You did it. And we need to start making them accountable for their actions. Yes, they should get there should be some way to eventually allow them to rehabilitate. But I think we need to worry more about our society and our victims and protecting them rather than protecting our inmates. Sorry for the bluntness. It's very close to home and emotional for me. It rules our life every single day and will. And we dread the day the man gets out. Any questions for me?
Thank you, Ms. Hoffmeister, for sharing that. It's always helpful to receive your type of testimony, and I know it can be difficult, so we really do appreciate it. Are there any questions for Ms. Hoffmeister? Thank you.
Thank you.
All right. With that, I'm going to close public testimony. Committee, what would you like to do here? Co-Chairman Washer.
Mr. Chairman, in the interest of time, I'd like to carry this bill over till our next meeting. My worry is that if we proceed with the amendments at this time, we're not going to conclude on time, and then we're going to be up against that hard deadline at 3:45.
Yep, I think that's fair. We move this bill forward to our next meeting. You've got the amendments that have been proposed to us, and then obviously if there's something that you're working on, Co-Chairman Washer, I know you're working on some language, so I think that's a really good idea. All right. Very good. Mr. Attorney General, we're ready for you.
Go. Okay. Mr. Chairman Olson and Mr. Chairman Washut and members of the committee, I am honored to be here for the second time now as your Attorney General. I've learned a lot in the last year and really appreciated working for you and working for the state of Wyoming. And I'm glad to present a little update, just so you know what's going on in the Attorney General's office and in general with the things that the Attorney General is assigned to do. I'm willing to try to answer any questions you have, whether about high profile things or not. I'm just really glad to do that. So let me start by giving you an overview of things that we do in the Attorney General's office or that are assigned to the Attorney General in addition to legal representation. And we're going to get to the legal representation at the end of the conversation. But in addition to legal representation, our statutes give the Attorney General the supervision of the Division of Victim Services, the supervision of the Department of Criminal Investigation, supervision of the Wyoming Law Enforcement Academy, supervision of the Police Officer Standards and Training, and sort of supervision of the Governor's Council on Developmental Disabilities. And then we have our law office that I will talk about at the end. I've been really honored to deal with all of those agencies in addition to the lawyers working for the Attorney General's office over the last year. And I'll give you just a little update from each of them and maybe a little bragging. Division of Criminal or Victim Services has a special place to my heart. I helped in the counties in the 8th Judicial District start victims programs way back in the 1990s. And our legislature has been good, I believe, about honoring and recognizing the role of victims in the process. Well, over the last year, we've had some big successes and wins in our victim services area. In the last year, the victim services programs throughout the state of Wyoming served almost 14,000 victims of crime. And so you can imagine how that takes a lot of effort and a lot of coordination. One of the interesting wins, I think, for this last year is that that Victim Services was able to increase their recoupment rate on crime victims compensation. So we have a crime victims compensation fund, and every criminal case has an allocation that goes into that fund, and then there's a way that victims can be compensated, and then they try to get the money back from the offenders. And we've been able to increase the recoupment rate by about 50% over the last year. So that's a big win. But I'm going to tell you the biggest win for Wyoming in the crime victims area this last year is that Kara Chambers, and you know Ms. Chambers, she's our director of victims compensation. She just was announced to be the winner of the Peyton Tuthill Crime Victims Assistance Award. Guys, folks, this is the #1 award in the entire United States for adult victims of crime. The #1 spot, and Wyoming got it, and Ms. Chambers deserves a tremendous amount of credit for what she did and does for our system. So, Ms. Chambers, well done. What a great system we have. So now let me go over the others. DCI, you know about DCI, and the crime lab is still really, really busy. Just in 2026 so far, I just checked, and they've received over 7,500 items of evidence that they have to identify and figure out what to do with. 325 additional biological cases they have to figure out. As far as the agents in DCI, we have 11 of them assigned to task force around the country. We've had significant increases in both fentanyl and methamphetamine seizures in Wyoming this last year. The ICAC team is really busy so far. They have initiated investigations on just about 1,000 cases in the year of 2026. And so DCI total has opened over 1,600 cases in 2026. And again, about almost 1,000 of them are from ICAC. So that's what DCI is up to. The Wyoming Law Enforcement Academy is just finishing remodeling projects, and you probably know about them. And I really urge you to stop by and see them when you go through Douglas. It was a good facility, but old and needed updating. And so they're just finishing up. They'll be done probably in a couple months with remodeling on the dormitory areas and some of the administrative areas. The next phase for the Law Enforcement Academy is there's a plan to improve their shooting ranges and their driving areas for high-speed chases and stuff like that. The academy is busy, virtually full in every class. The academy continues to get awards, national awards, and to be a presenter. We're kind of on the cutting edge of advancing training for law enforcement officers. So things are going okay. Well, I believe at the Law Enforcement Academy. The police officer standing and training got a new administrator at the same time as I came in. His name's Robert Terry. He's a former officer from Laramie. And since he's been there, we've switched the attorney from the Attorney General's office that works with them as well. And now that's Ms. Callie Martinez from here in the Casper office of the Attorney General's office. And I'm going to brag about them a little bit. Since Mr. Terry's been there, they've reduced the backlog on post cases by about 50%. And we're getting close to where we can resolve post cases within a couple months. How fast we do that is really important to me, and it's important to the agency. So big success there. We're also working on updating the standards that Post uses, and those are, it's sort of like what you guys do in looking at the laws and what kind of standards should we have. And we're comparing what Wyoming has to other states, and we're working on updating those things. Let's see, on the Governor's Council of Development of Disability, the Attorney General's office is really just responsible for financial management, and our financial people take care of the funds, but the Council on Developmental Disabilities runs their own show, and they report to the governor. And so, as you know, they provide programs in many, many local communities for developmental disability. So that's the background for the other things that we do besides the law office. And now I'll go over the law office work. Boy, I've been honored to work with these guys, with these folks. We have spots for 67 attorneys and 20 paralegals in the law office. Those are broken up primarily, but they primarily exist in Cheyenne in the Pioneer Building. And I invited you a year ago, and I'd invite you again. If you're down there and don't have, I know how busy you are, but if you want to see what they do and how they work, I'd love to have you come by the office. Then we have 4 attorneys and a paralegal here in Casper, and they primarily deal with the Oil and Gas Conservation Commission, which is here, and they also have an emphasis on workers' compensation that lets employers and employees from the north half of the state not have to go so far, and they can get directly developed. But that's what we have for our office. We have only 4 attorney vacancies at the present time and 3 paralegal vacancies. And Representative Lean, I'm going to thank you for your work on getting state employees a raise, especially for our younger age, younger experienced attorneys. They were way behind, probably about 50% behind private industry and what the starting salaries were. So it really has improved things for the Attorney General's office and for representation for the state. That law office is broken up into 5 divisions, and we call them civil, criminal, tort litigation, and water and natural resources, and human resources. So those are the 5. Each of them has a deputy, and now that I've gotten to know those deputies, if I was starting a law firm here in Wyoming, I'd want to snatch every one of those deputies and we'd have the best law firm in the state. But I'm really proud of them. We have some outstanding attorneys running those particular divisions. So let me go over with you a little bit of what each of them does. In the civil division, primarily the civil division advises state agencies. So in there, the lawyers provide legal work for about 115 state agencies and state boards. They go over their rules and regulations, they answer questions for them. And when they get into some sort of litigation or potential litigation, they usually represent them, although we can spread that out other places in the office as well. A lot of the high profile cases that you have read about in the paper over the last year, the civil division represents the state in those things. So, I could give you examples, the Hot Springs State Park case and the cases involving the Secretary of State and those things, all are represented by the civil division. The criminal division represents the state in criminal appeals. They don't represent the state in prosecuting crimes. That's the county and district attorneys, but they represent the state in criminal appeals. And as you know, every felony defendant in the state has a right of appeal to the Wyoming Supreme Court in their felony case. And so we have a division there that works on those kinds of appeals. In addition, they represent the state on any kind of federal prisoner litigation involving criminal stuff. So that would be habeas corpus, those kinds of things. In the federal government, they represent the state in forfeitures, in criminal forfeitures. And the criminal division also has Medicaid Fraud Recovery Unit. And the Medicaid Fraud Recovery Unit, that's a big deal in the national news, and it's a big deal to Wyoming. Actually, we have 4 people that are working there. So we have an accountant, we have a paralegal, we have an investigator, and we have 1 attorney. And between the 4 of those, they've recovered over $2 million for the state of Wyoming in the last year in Medicaid fraud. There are a number of areas where we have identified that they could do additional work, but there's not enough people to go around. So how this Medicaid fraud unit works is the federal government pays 75% of the cost of personnel, and the state pays 25%. So we're going to ask for 1 more person and ask the feds to pay for that 75%. And we think there are additional areas that we can go in, and it will be money well spent. Interestingly, today is federal audit starting of that unit, and they audit those Medicaid fraud units once every 10 years. So we embarked on a self-audit a couple months ago and went over it, and I think we're gonna look good. We recover probably more per person in the office than any other unit, but that's because we have by far the littlest office. So that's what our criminal folks do. Human Services is a big division, so they represent the Department of Health. They represent the Department of Family Services. They do have all of the consumer protection folks, and they are busy all the time. In the Department of Family Services, there are a number of attorneys there and paralegals who do go to court a lot, because under our Wyoming system, if a parent's rights are ever going to be terminated, usually our lawyers are the ones who prosecute that in the courts. And then our lawyers follow up with, how do we find permanency for those kids? And that's the goal in those cases. And over this last year, we've had about 80 kids that we were able to provide permanency for, that their families unfortunately had fallen to pieces. So I'll brag about them a little. In the consumer protection area, you probably know we got a big settlement from the tobacco companies, and every year we get money from that. And every year we have tobacco programs and lawyers that work on that, and we go and investigate to make sure that all that is being carried on around the state correctly. We got I'm trying to remember the name of the generic. It's drugs. And what is the name of this stuff? It's not fentanyl, but we got a big settlement from pharmaceutical companies who are overprescribing and oversending out narcotics, and we have attorneys that work on that. Our consumer protection attorneys really enjoy working for Wyoming people. And so we have investigated and prosecuted a number of consumer protection cases where usually those are where some company has come to town and they're using some false advertising or some false financing and taking advantage of people. And we see that a lot with seniors. And so we work on that kind of stuff. Tort litigation division. The tort litigation division includes the school finance division. And then they also include a litigation section that handles all workers' compensation cases on behalf of the state and all employment cases on behalf of the state. And as you can imagine, there are quite a few of those. That unit also represents a lot of the teacher standards and professional standards things when we have state employees that have to have licenses, and there's questions about them, they get involved with that. It's one of the unfortunate facts of life, but you might be interested to know that we have about, at any given time, and today I think there are 44 lawsuits against the state in one form or another for some kind of personal injury that somebody says they suffered at the hands of the state employee. Now, how many of those are good cases? I don't want you to think that I think they're all good cases, but we defend them, and we defend them well, and some of them are serious cases. And we need to have good lawyers who can defend those kinds of cases. And then we have Water and Natural Resources, which is kind of a flagship of Wyoming. And you're familiar with the Colorado River litigation. That's our biggest concern. There's just no water in the Colorado River. And we have, and with your help, you provided some funds. We have good nationally recognized attorneys on board to help Chris Brown, who's the #1 guy in the country on this, defend Wyoming legally. Sometimes it appears to us that some other states would prefer to make this a political issue instead of a legal issue. And when you read reports from some of those states that will go unnamed, but they start with A, Z, they think that that's the solution for them, and probably because I don't know. They have a lot more people, and they have a lot more political clout. And Wyoming is in a pretty good position with our upper basin states. We cooperate and work together, and so what's going on right now is the Bureau of Reclamation has said that, there's obviously not enough water to run their hydroelectric dams. And so they're going to take over how water is released from any of the reservoirs in the system to make sure those hydroelectric dams keep going. And they came up with a plan. And the plan is a little more closer to what Wyoming and the upper basin states would think is the law than the lower basin states. So the lower basin is squawking about it, and we'll see where that all ends up. Water and Natural Resources also handles all kinds of environmental and natural resources cases. You can imagine the whole gamut. They represent the Border Control and the state engineer in all kinds of water law in Wyoming. They represent the Game and Fish Commission, and they represent the state's interests with respect to endangered species and Environmental Policy Act. And we have about 50 cases of that nature going on right now. It was interesting to see what happened before the federal administration switched. Wyoming was participant in suing the federal government on a lot of those cases. And then the federal administration switched, and the Department of Justice and Department of Interior have switched. And so now other entities are suing the federal government who don't like the new policies, and those cases will affect Wyoming. And so we've participated often on the side of the federal government on the back end of those. The last thing I'll mention is within our civil division, there's a contracts unit, and we have 4 lawyers in there, and they are obligated to review every contract for the state of Wyoming and understand it and put their stamp of approval on it before it goes out. And that's a huge job. Year to date, I just checked, they've reviewed and approved 5,248 contracts. And there are some lawyers in there who have really special expertise. So one of the areas of expertise is with IT contracts. Turns out there's a lot to those that I didn't have any idea about. And I'm glad we have those guys reviewing those for you and for all of us. So there's kind of my report. I'm happy to answer any questions. And as I said, we're all kind of on the same team here, and I'm glad to work with you.
Thank you. Representative Washit.
Thank you, Mr. Chairman. Really glad you're here. It's just wonderful to have the Attorney General come to our meetings, and I just appreciate your driving all the way up here to be with us. But I do have a couple of comments that I promised to make. All is not well at the Wyoming Law Enforcement Academy, despite their awards. I continue to hear from chiefs and sheriffs, especially from my police chief here in this city. They now put on a 9-week academy subsequent to WLEA because they are dissatisfied with the skills that officers are returning from WLEA with. So we probably don't have time to delve into all of that, but I just encourage maybe someone in your office outside of the academy, maybe reach out to chiefs and sheriffs and gather some candid feedback. We're going to be asked to spend millions of dollars on driving and shooting facilities. And gosh, I would really hope that the chiefs and sheriffs would be the biggest cheerleaders behind the law enforcement academy as we move forward. And that doesn't seem to be the case presently. So thank you for being here.
Mr. Chairman, if I could respond.
Yes, please, Mr. Attorney General.
Chairman and members of the committee, there's an advisory board for the WLEA, and it has 2 police chiefs and 2 county sheriffs, and I'm on it, and we welcome any sort of comment and criticism and evaluation, and we want to do our best. Thank you.
Representative Lean.
Thank you, Mr. Chairman. Thank you for joining us. I appreciate your time. My question is about the crime labs and what our staffing looks like. What does time-wise look like for turnaround for the judicial portion of our state to be able to continue to carry out those cases?
Mr. Couts.
Mr. Chairman, Representative Lean, can you be a little more specific about what timeline and which particular cases?
Representative Lean.
Mr. Chairman, particularly, how does staffing look for you within the crime labs? Could you use more staffing? Is your equipment up to par? What does that look like?
So, Mr. Chairman and Representative Lean, we have a great report that shows turnaround times, and we are at a good place on turnaround times compared to the last 10 years. Now, whether that's adequate for prosecutors is another question. But I will get you very specifics on how much turnaround time there is. I just know that I looked at the charts and we're in a good spot. We're getting those cases cleared faster than they were in the past. That's as much as I can tell you. But we want to do that. There shouldn't be any delay.
Representative Webb.
Thank you. And I just have 2 quick comments. One, I'm glad to hear the recognition for Mrs. Chambers. I've used her many times, and I'm very confident in referring to people to her. And so I've always appreciated that. Number 2 has to do with water. I live at the very top of the Colorado River. We're under water restrictions. And it's kind of interesting for me that we're under water restrictions, but downstream, I see a lot of golf courses, and I see a lot of public and backyard swimming pools that don't seem to have any restrictions in some of those states that you've mentioned, like AZ. And I just want you to be aware of that, because sometimes I think that message doesn't get delivered to the places that it needs to, and I wanted to deliver it personally to you. Thank you.
Mr. Chairman and Representative Webb, thank you for your observations, and your observations are not lost on us. And I know Chris Brown is, and our experts are trying to present the real picture as much as we can. So thank you. Yes, I agree.
Representative Filer.
Thanks, Mr. Chairman. Attorney General,
on the same lines as water and understanding senior water rights all the way down to the lower basin, coming all the way up to here. One thing that I've been noticing too is the amount of time and money that all the lower basin states are putting into this Colorado River Compact, the resources that they're putting it towards it. How is your office being able to handle that? Or do you need the more resources to be able to combat any of that?
Mr. Chairman and Representative Filer, the legislature gave us what we asked in the last budget, and that'll last this 2-year budget cycle. It's very likely that that will need to be replenished with the same amount coming up. So I'm going to say, from our point of view, we're in fairly good shape on finances for attorneys, and to some degree on finances for technical experts. Some of that is connected with the state engineer's office, however, and I can't comment on his budget. I know that comparatively, we're spending a drop in the bucket from Arizona and California. But we have to be cognizant of our state's budget as well. And we actually, I'm not here saying we don't have enough right at the present time. I think we're putting up a really good defense. Now, I need to say also, I mentioned Chris Brown is recognized as the top guy. If Chris were to go to work for one of these other firms, Wyoming would be in a world of hurt. Yeah.
All right. Thank you, Mr. Attorney General. I echo the comments of my co-chairman. Really appreciate you being here, driving up here to talk to us and educate us more about your agency.
Thank you, Mr. Chairman. Thank you very much.
All right. With that, it's lunchtime. We're only 15 minutes behind schedule, but I think we should keep it on schedule. So let's still plan to be back here at 1:30. Gives you about an hour and 15 minutes. Should be enough time. All right. Thank you.